All right, Ms. Rivers, are you ready? Great. Well, let's get on the record. This is 23 SC 187925, State versus Charles. Mr. Charles is charged with the May 2017 murder of Jeremy Braswell. And we are here this morning to talk about a motion his lawyer, Mr. Apt, has filed seeking to suppress or exclude identification evidence. So let's have the appearances for the two sides, and then I've got a few questions, and then we can get rolling. For the state.
Good morning, Judge. Vincent Fawcett, State.
Good morning, Mr. Fawcett. How are you?
I'm just fine, thank you.
Are you the ADA to handle this through trial, or you are covering for Mr. Abadi, who usually handles stuff in my courtroom?
It's a sign.
Great. All right. And we've got for Mr. Charles.
Good morning, Your Honor. Jay Apt on behalf of Mr. Charles. He's present in court, and we're ready to go.
Okay. Mr. Apt, tell me your understanding of what kind of identifications were made. So are you seeking to suppress a show-up ID, a photo ID? Just lay it out there, because there were a few names. Your motion had some specifics for the case, and then lots of your view on the reliability of identifications.
So there's three separate identifications we're seeking to suppress that we are to some degree particularized in our motion.
Yep.
One is made by an individual named Queen Booth, who is the manager of a hotel where this alleged incident takes place. That, in my understanding, is a photo lineup identification.
Standard 6 images.
I
Not sure.
Yeah, it is. Let's see.
This case is old enough that in theory it could have been what they call the 6-pack, although hopefully by this point in time, the officers were just handing 6 photos and the person moved through them as she.
5. Yes, 6.
Okay. So 6 images.
6 images, Your Honor.
Queen Booth.
Queen Booth.
Okay.
There is also, and it's a little confusing, but there is a security guard who makes a partial identification. Her name is Christina Ballou, and we are challenging that identification as well. That is not a photo lineup.
When you say partial identification, like, hey, that's his left arm?
No. So Ms. Ballou, according to the discovery evidence, says, if you'll just give me a moment, Your Honor. She identifies the individual she thinks may have committed the crime and the victim of the crime by their nicknames and having, I guess, previously seen them at the apartment. So she doesn't actually witness the crime, but she provides some partial identification of my client in the case.
Because she's shown some pictures, or she just is talking with the detective and says, hey, I know it was Slim and Lefty who got into the fight.
Slim and Bulldog. And so she doesn't, she provides what I would say is a very partial identification of both the victim and the defendant.
What's the law enforcement? The first one with Booth, I understand you'd be suppressing. It was a suggestive lineup, or the detective said, hey, I sure like photo 2. How about you?
Right.
But with Ms. Ballou, if she's just given an interview and says, hey, Slim and Lefty.
Identifying Slim as the person who potentially, or the person who commits the crime.
Right.
And
Describe what law enforcement did that would make that suppressible, as opposed to maybe it's speculative or something. And so we would deal with her testimony.
You know, I cite a bunch of studies in our motion about how unreliable witness identification is.
Okay.
And she's relying on, and I not only do I cite studies, but we also talk about how that potentially violates due process based on some of the case law, including Biggers and then Georgia cases like Glass. We cite in our motion to argue that the state needs to have a higher burden of both what the case law and the studies suggest are both accuracy and confidence of the witness in terms of identifying who an individual is that could violate my client's not only confrontation clause rights, but due process rights.
But Ms. Ballou, I'm sorry to keep interrupting you, but Ms. Ballou is not going to say, the police showed me a picture and I said that's Slim.
I don't believe so.
She's going to say either I heard, which is problematic for a different reason, and probably is not coming in. I heard Slim and Lefty, as in someone told me. It'd be different if she said I heard, as in they were within earshot.
Well, I mean, I can make a hearsay objection at trial, obviously.
You sure can.
But she's claiming that the victim frequented, she heard gunshots.
Okay.
She can testify to that.
Yep.
She claims the victim frequents the area but does not live there. Okay, maybe she does. She claims the victim goes by the name Bulldog and usually frequents rooms, 3 different rooms. Ballou stated that she heard residents talking about a robbery that took place earlier that day at the Knights Inn, a different location, and that there was a retaliation shooting sometime tonight. And then Ballou later is interviewed by a different detective, it looks like, and a guest approached her prior to the shooting and told her the shooting was about to occur. Apparently a robbery had occurred and the victim of the robbery wanted to retaliate. It is unknown when or where the robbery took place. The victim of the robbery is possibly the suspect of the homicide.
Got it.
According to Ms. Ballou. So, you know, to the extent she's going to try to testify that the victim of the prior robbery is the person who committed the homicide, I think that violates my client's, it may be hearsay.
Right.
But more important, I'm not challenging the hearsay today because I can do that at trial. I am challenging her testimony to be excluded, that testimony to be excluded, that the victim of the prior robbery is the one who committed the homicide, based upon both confrontation clause and due process rights that my client would have in her identifying who Mr. Charles is.
Okay. And how about Anastasia White?
And her testimony is maybe the most interesting. She is a resident of the hotel where this all occurs. And her testimony is also problematic from a confrontation clause standpoint. And if I can just have a moment, Your Honor, to locate where Ms. White advises she overheard the suspect saying he was going to shoot someone earlier in the evening. When she heard the gunshots in the leasing office, she hid behind the counter. She described the suspect as a black male, around 5'8", dark complexion, heavy set, beard and mustache, did not have a name for the suspect. And so, again, she's identifying an individual who is the alleged perpetrator of the crime. And I think, but she's claiming she didn't see the crime occur. She's claiming she spoke with someone who said they were going to perpetrate this crime. And I think the police are relying on that information, Your Honor. And
did she ever say, was she ever shown pictures, as far as you know?
I don't know. And
Okay.
so I don't know.
Well, as far as you know, she wasn't. There's nothing in discovery.
There's nothing in discovery to suggest either Ms. Ballou or Ms. White were shown a lineup.
Okay.
So I'm not challenging under the traditional lineup theory. I am challenging the lineup shown to Ms. Booth.
Yes.
But I'm challenging Ms. Ballou's and Ms. White's testimony based upon the the studies I cite, the accuracy, confidence that law enforcement are going to rely on that, and that I think creates a due process issue for my client and a confrontation clause issue for my client.
Okay. I understand your argument, but Ms. White never said Mr. Charles did it. It sounds like what she did was tell the police 5'8", dark skin, beard, mustache.
Yeah, I almost want Ms. White to come and testify because Mr. Charles is like 6'3" and isn't heavy set and doesn't have a beard or a mustache. Didn't at the time.
Sure looks like he does, but
he didn't at the time.
okay.
But I mean, he's not heavy set and he's very tall. He's way taller than 5'8".
Got it.
So I almost want Ms. White to testify, but I don't think it's. I think it's, if I'm going to ask the court to exclude other individuals, then I should, what's good for the goose is good for the gander. I think all of these witness statements are problematic from a constitutional standpoint, and so I'm asking the court to suppress them.
Thank you. Mr. Fawcett, do you agree with the facts that Mr. App provided in this one sense, that those three people made identifications in the way he described? I'm going to recap because you can say, yes, that's right, or let me correct it. Ms. Booth, we're in that classic, she was shown a photo lineup and she picked number X, whatever it was. And I know that dynamic, and you're going to need to get a witness here and we'll work through that. Ms. Ballou didn't identify anyone. She talked about things she heard. I don't know that that's coming in, but to me, that's not a identification situation. It would be in trial. If it's hearsay, it's hearsay. And maybe it's not because there's a prior consistent statement or who knows what. But I think we navigate Ms. Ballou by way of contemporaneous objections if the state even sought to elicit the hearsay. And we might have a motion in limine to make sure that that question's not asked and then she answers it and we have to unring the bell, and you'd be identifying the exceptions to hearsay or that it's not hearsay. And then finally, that Ms. White actually didn't identify anyone. She did what we see all the time in cases. The police say, well, what did the guy look like? And she said, whatever she said, and it's a good fit or it's a bad fit, and you're stuck with what she said. And if Mr. Charles doesn't fit that, then Mr. Apt has a heyday highlighting for the jury the difference between what Ms. White said and Mr. Charles's appearance.
That's exactly, Judge, and working my way backwards, I did not view the statement of Ms. White as a favorable statement to the state, given Mr. Charles's height. That wasn't consistent with the statement of Ms. White. But to the extent that she hears shooting and describes what she saw and heard right after that, I think that would be admissible, just as long as that foundation is laid. I did not see a way for Ms. Ballou's statement to come into evidence based on what she heard, especially the previous murder, unless she was present for both events. So I didn't anticipate.
Sounds like she heard a lot in terms of word on the street. She didn't see anything. Nothing came directly from, hey, this guy told me, and you think that's the defendant. That could come in. It's what she was hearing from others. So you don't expect to elicit from Ms. Ballou those things she heard about, hey, there had been a robbery before, and I heard the victim of the robbery was coming back for vengeance to get the robber.
I would not purposely do that. I would try to avoid it.
Okay. And then Ms. Booth is, we're just going to work through the photo lineup and how it was presented and all that.
That's correct.
Okay. So Mr. App, I think you have put me on notice of your concerns about Ballou, although it sounds like while they are well-founded, the state's not going to be going there because they can't, because it's hearsay. And then with Ms. White, I don't know that I need to hear more from Mr. Fawcett, because if Ms. White does testify and the state asks, well, what did you see? And either she says something different and then you can impeach her with what she said, or she'll repeat what she said and it was a short person. And then you go to her, it's the weight of her evidence. I think it comes in that her recollection is the guy was 5'8". And then you do what you do well. Mr. Charles, stand up in front of these jurors. And they all look and say, the guy, so.
We call that reasonable doubt.
Right, exactly. So I think our focus this morning is the identification that Ms. Booth made and the circumstances surrounding that, so that I can make the determination whether there was anything unduly suggestive about what the police did, that it's 5 guys wearing masks and 1 not, and that's your client. Or like they said, the detective's like, hey, what about number 2? So I don't know if it was recorded, but the burden is on the state. You don't need to do anything up front. Mr. Fawcett's going to present what he is, and then you'll be able to cross-examine, and we'll go from there.
And I'm happy to file a motion in the if the court wants, but since it sounds like the state is a little bit conceding that Blue's testimony is hearsay, can we just include that in whatever court order we have for today, and then that way we've resolved it?
Yeah, well, I mean, what I'll do.
Judicial efficiency.
No, I'm fine doing that, but what I'll do, I haven't read the police reports of this or that, but I will say insofar as her knowledge about what supposedly happened is based on hearsay, the state should not explore that without us having a outside the presence of the jury huddle first, because doors could open where it does come in. But as it stands, Ms. Ballou will be talking about other things than what she heard from residents of the hotel or friends on the street or whatever. Okay. Mr. Fawcett, however you want to proceed with the photo lineup.
Thank you. I'll get my witness is Lieutenant Moss with
Great.
Southwood Police Department.
Someone saw Baloo for me.
I've got lots of copies.
Ballou. You bet. Sorry about that. And it's Christina, Kristina. Queen Booth is standard spelling.
Praise me, raise your right hand. You swear affirm that the testimony you will give the truth, the whole truth, and nothing but the truth of God.
I do.
And you stated your name for the record.
Nikita, Nikkita, Moss, Moss.
Good morning.
Good morning, sir. How you doing?
I'm well. Thanks for being here.
And what is your official rank and title at the police department?
I'm a lieutenant with the South Fulton Police Department in the Criminal Investigations Division.
How long have you been in law enforcement?
16 years.
All right. And can you tell the court what your duties are?
I oversee the detectives in their criminal investigations, which include felonious crimes such as murders, ag assaults.
Okay. And at any point, did South Fulton take over for the Fulton County Police Department?
Yes, sir.
All right. And were you working in law enforcement in the year 2017?
Yes, sir.
And what were you doing in and around that period?
At that time, I was a detective.
Okay. And is it part of your agency's responsibility to prosecute homicide cases?
Yes, sir.
And you tell the court in prosecuting or investigating homicide cases, do you sometimes utilize photographic lineups?
That's correct.
Okay. Can you tell the court what a photograph?
I'm sorry to interrupt. In 2017, did South Fulton exist? Were you South Fulton then, or you were Fulton County PD in 2017?
We were in the process of transitioning over. So we were South Fulton, however, we were Fulton County, South Fulton, however, we were still acting under Fulton County PD.
So if I called 911 from the scene that we're going to talk about where this homicide occurred and you roll up, does your police car on the side say South Fulton Police?
At that time, it still said Fulton County PD.
Okay,
We were covering South Fulton areas until we fully transitioned over.
got it. So you, I don't know if migrated is the right word, but you migrated from Fulton County Police into South Fulton where you are now.
Correct.
And this situation occurred during that transition.
That is correct.
Got it.
And are you familiar with investigation related to Rodnell Charles?
Somewhat, yes, sir.
Okay. Were you the lead detective on that case?
No, sir, I was not.
Who was the lead detective?
Anthony Alexander.
And he would have been assigned this homicide when it occurred in 2017?
Yes, sir.
And how did you become involved in assisting Detective Alexander with this case?
He needed a photographic lineup presented, so I assisted in presenting the lineup for him.
Is that common for lead detectives to get assistance with executing, performing photographic lineups?
Yes, sir.
And why is that?
Just to keep the bias out of it. I didn't know who the suspect was at the time. So in presenting a photo, I couldn't lead the person into choosing the person that he suspected to be the shooter.
Okay. Is that pretty common practice at that time at Fulton County Police Department in 2017 to get, I guess, an uninvolved assisting detective to perform that?
Yes, sir.
Okay. And who would have prepared the photographic lineup?
Detective Alexander.
All right. Now, have you yourself prepared lineups in investigating criminal cases?
I have before, yes, sir.
And when you're preparing lineups, what types of factors do you try to take into account when you're preparing a lineup?
We try to use light photos such as complexion, hairstyle, facial hair. If they have piercings or tattoos, we try to use likeness to not insinuate who the person may be.
Okay. Do you also take into account the age of the individual as well?
Yes, sir.
And talk about the procedure for administering a photographic lineup. How's that done?
There's a photographic lineup affidavit, which I would read out to them, make sure they understand the affidavit, which also explains concentrate on the features, not the hairstyle and whatnot. After reading the affidavit, I would hand them all 6 photos, which should be numbered 1 through 6, and allow them to go through the photos on their own. And once they pick out a photo, if they pick out a photo or not, then we'll go over the 3 categories of their choosing.
Okay. And your testimony is at this point, say you were assisting Detective Alexander. Did you have any information as to the facts of the case at that time?
No, sir.
And your testimony is that you didn't have any information as to the identity of the person believed to be involved.
Correct.
Okay. And so, did you in fact assist Detective Alexander with the photographic lineup?
I did.
And was anyone else present with you when this occurred?
As far as presenting it or another officer? Not that I recall.
All right. Do you recall where this took place?
I believe it was at the hotel where the incident occurred, or at the hotel where the witness was.
Okay. And when you were, do you recall, I know it was a while ago, but generally how long would, say, a photographic lineup take?
Just as long as the person needs, generally maybe 10, 15 minutes at max.
Okay. And if there, do you keep any type of documentation or make notes or summaries, either yourself or the person that's with you assisting, to kind of document what took place at the time the photographic lineup was done?
Once it's presented, typically the person that presented it or who it was presented for would document the findings of it.
Okay. Do you recall any documentation as to whether or not the individual that you met, Ms. Booth, whether or not she appeared hesitant to make the identification? Do you recall that at all?
I don't recall.
Okay. Do you recall whether either yourself or anyone involved did anything to make any type of suggestion as to who it may or may not have been?
No, sir.
I can approach the witness, Your Honor.
Yes.
When I hand you what's been marked as State's Exhibit 1, you can tell the court what that exhibit is.
It's the photographic lineup affidavit along with the photos that was presented.
Okay. And that first page, does it contain that photographic lineup?
Yes, sir.
And are there 6 photographs after that first page,
Yes, sir.
all contained in State's Exhibit 1?
Yes, sir.
And is that the lineup that you presented to Ms. Queen Booth, assisting Detective Alexander in the year 2017?
Yes, sir.
Your Honor, at this time, the state moved to tender in evidence State's Exhibit 1, which is the photographic lineup and the 6 photographs.
Any objection for purposes of this hearing, Mr. App?
No objection.
Exhibit 1 is admitted.
Lieutenant Moss, could you read the admonition into the record?
Yes, sir. In a moment, you will be shown a group of photographs. This group of photographs may or may not contain a picture of the person who committed the crimes now being investigated. The fact that the photographs are being shown to you should not cause you to believe or assume that the guilty person has been caught. Keep in mind that hairstyles and facial hair may be easily changed. Also, photographs may not always depict the true complexion of a person. It may be lighter or darker than shown in a photo. You should study only the person shown in each photograph. When you have looked at all of the photographs, please state whether or not you see the person who committed the crime. If you can, please tell me in your own words how sure you are of your identification. Do not tell other victims, witnesses that you have or have not identified anyone.
And was, you recall whether or not that was in fact the admonition that was read to Ms. Booth?
Yes, sir, I signed it.
And subsequent to that, is it your recollection that she was able to identify the person that she was trying to point out for law enforcement?
She identified someone. I don't know firsthand at the time if that was the person responsible for the incident.
Okay. Do you see anything written on, any documentation noted on that exhibit by Ms. Booth?
She checked, I positively identified number 5 to be the person that I saw commit the crime.
Okay. All right. I would publish statements exhibit 1 to the court.
Great. I'm actually going to keep it.
And, Lieutenant Moss, after Ms. Booth, made the identification, did you have any other involvement in this case?
I don't recall.
Okay. That's all I have with this witness, Judge.
All right. Mr. App, do you have questions for Lieutenant Moss?
Yes, thank you, Your Honor.
Sure.
So,
I have one before you start. I'm sorry. Lieutenant Moss, what I have as states exhibit 1 is the affidavit, like you described, and then 6 photos. They're all numbered. On photo 5, Ms. Booth wrote something, the one she identified. They're all black and white photos, 1 photo per page. Is that how they were when you gave them to Ms. Booth, or were there color photos and we're working with a black and white copy of the color photos?
No, sir, we don't print our photo lineups in color.
Okay,
So they're
so
always black and white.
this is essentially what Ms. Booth was looking at. It's not the original because it doesn't have ink on the page she wrote on, but this is pretty much what it would have looked like for her.
Yes, sir, it's a copy of black and white photos.
We don't need to worry that one of them had an orange background and 2 of them had purple backgrounds.
No, sir.
They're all gray, black, and white.
That's correct, sir.
That's helpful. Thank you.
How you doing?
good morning, Lieutenant. How are you?
I'm well, how are you?
I'm doing well, thank you. My name's Jay Apt. I represent Mr. Charles. So I want to start with, you've been law enforcement for 16 years, so I'm going to safely assume you're post-certified.
Yes, sir.
I didn't hear it on direct, but I just figured for the record, we'll get that out of the way. You were a detective with Fulton County at the time of this incident, correct?
That's correct. Transitioning into South Fulton. Yeah.
But still technically a detective in homicide for Fulton County, yes?
Yes,
Okay, now you're the lieutenant over all of CID for South Fulton.
correct.
Congratulations.
Thank you.
And thank you for your service. And so I guess my first question is, or first line of questioning is, other than being involved in showing the lineup to Ms. Booth, did you question her about anything she saw or observed or any information she had regarding this case?
No, sir, because I didn't have full knowledge of the case. If there was questioning, it came from Detective Alexander.
In your testimony on direct in Exhibit 1 that the state has presented, she checked the box saying that she has positively identified number 5 as the person that I saw commit the crime, correct?
Yes, sir.
Would it be of surprise to you then that in the investigative reports and other evidence in this case, she did not testify, she did not give information that she saw anyone commit the crime. She didn't observe the crime committed at all.
I wouldn't have knowledge to that, sir.
You don't have any knowledge of that.
No, sir.
She was only questioned, are you aware or not aware that she was questioned by your colleague, Mr. Anthony Alexander, and she was only providing information about what person rented room 339 at the hotel?
I have no knowledge of that.
No knowledge.
No, sir.
So you don't know whether she committed the crime, whether Ms. Booth saw the crime committed, whether or not she observed the crime committed, whether or not she was simply identifying who was from a particular room.
That's correct. I was only asked to present a photographic lineup.
And so you don't have any knowledge or information about what Ms. Booth was actually identifying.
No, sir, I don't.
Okay. And you did not have any questioning of Ms. Booth about whether she had an opportunity to view Mr. Charles or the person she thought at the time the crime was committed, correct?
That's correct.
Did you question Ms. Booth about her degree of attention at the time of the alleged incident?
The only interaction I had with her was presenting a photographic lineup.
So you did not question her about the degree of attention she had.
No, sir.
You did not question her about the accuracy of the prior description she had given of the witness.
No, sir.
You did not question her about the level of certainty of her at the time she witnessed the whatever it is she witnessed, because you don't know what she witnessed, right?
Correct.
So you didn't question her about her level of certainty.
Correct.
You did not talk to her about the length of time between whatever she's alleging she saw and the time of the lineup, correct?
Correct.
And you did not question her, like on a scale of 1 to 10, her confidence in identifying the individual, correct?
No, sir. If you look at that affidavit, 1 through 3, one says I positively identify. The third one is where we would ask percentage if she wasn't 100% sure.
Okay, so are you saying she was claiming she was 100% sure?
I would assume so because she positively identified 5. On the third one is where we would do a percentage.
I really don't want you to assume anything. Did you ask her, did you ask her if she had 100% confidence that the individual she identified was the individual in question?
No, I did not.
Did you ask her, and separate from confidence, it sounds similar, but the term of art, so I really do want to be careful about it. Did you ask her about the level of accuracy of identifying the individual in question?
No, I did not.
And just a moment, Your Honor, please.
Mm-hmm.
Are you the one that selected the photos for this lineup?
No, I did not.
So you don't know where the other images came from?
No, I do not.
And you did not make any determination about whether the images were too similar or too different from the photo of Mr. Charles in number 5, correct?
That is correct.
Thank you, Your Honor. I have no other questions.
Any redirect?
Detective Moss. Lieutenant Moss. Your testimony is that if, is your common practice if the individual isn't able to make an identification or isn't certain as to the identification, you will ask for a percentage?
That is correct.
And to the best of your recollection, was Ms. Booth presented with those 3 options as to whether or not she could positively identify whether she was unable or whether or not she was unable to positively identify or just couldn't make an identification at all? Was she presented with all 3 of those options?
That is correct.
And when you went to the hotel, your understanding was that that's where Ms. Booth was employed?
That's correct.
And was it also your understanding that she was employed there as a manager or I guess a worker at that establishment?
Under the understanding she was an employee there, I didn't know what capacity.
Okay. And was it also your understanding that the individual in question may have resided or lived at that location for a period of time?
That's correct.
And was it your understanding that Ms. Booth was able to potentially identify that person because of her consistent employment at that particular location? Was that your understanding?
That's correct.
And was it also taken into account that the number of times and the consistency of her employment would have provided her a basis to have regular contact with that particular individual that she identified,
That's correct.
associated with room 339?
That's correct.
And was your understanding that Ms. Booth was the one that was able to provide that actual room number for the person she was identifying? Is that your understanding?
I believe I learned that after the identification from Detective Alexander.
Okay. And have you had an opportunity to review any indication from the notes and reports from this photographic lineup execution, whether or not it was noted if Ms. Booth was hesitant? Do you recall any notation of that?
I don't recall the hesitancy, but I do recall after the fact it was noted of the room number.
Okay. If I were to show you a copy of that report from Lieutenant Pritchett, when the two of you went to go meet Ms. Booth, would that refresh your recollection as to whether or not there was any mention of hesitancy on the part of Ms. Booth?
Yes, sir.
You can just take a look at this to yourself. To check with refresh your recollection as to whether or not any hesitation was noted on the part of Ms. Booth.
No, sir, I don't see any hesitancy.
And would it be customary for officers in your ranking position to make a note in a homicide investigation file if that was in fact the case?
Yes, sir.
And would you have made that notation on the state's Exhibit 1 if that was in fact the case?
Yes, sir.
That's all I have, Judge.
Any recross?
Very briefly, Ron.
Famous last words.
Yeah, right. So you just testified that you became aware of the fact that she was, Ms. Booth was the hotel manager, but that information was supplied to you by the other detective, correct?
Yes, sir.
You didn't question Ms. Booth, correct?
I did not.
The fact that she had identified a particular room number was not something you asked Ms. Booth.
That's correct.
The fact that Ms. Booth, whether she witnessed the crime or was just testifying to what a particular individual looked like who was in a particular room, you didn't have any personal knowledge of that information, correct?
That's correct.
And so all of those lines of question, that was all information that you're relying upon another detective for. It wasn't information that you had direct knowledge of, correct?
That's correct.
Can the lieutenant step down?
No objection?
Great. Thank you for your time. Appreciate it.
Thank you.
Mr. Fawcett, any other witnesses?
No further witnesses.
Mr. Apt, any evidence from your side?
Just argument, Your Honor.
Okay. Mr. Fawcett, before we get into argument, what is your understanding of what Ms. Booth will say about having seen the shooting as opposed to, I know people at this hotel, and so this was demonstrating that the person she was saying lived in 339 or was known as Slim was in fact Mr. Charles?
From the detective's report, is my understanding from that is that they were using this booth to tie in the connection between room 339 and Mr. Charles.
Got it.
That was the connection.
And so it may well be that what you do at trial is say, do you see in court the person who you associate with room 339, having laid an appropriate foundation? Maybe she identifies Mr. Charles, maybe she doesn't. But the value to the investigation of the selection of photo 5 was not, that's the shooter. It was, that's Ms. Booth talking. The guy I know from room 339 is number 5.
Unless I talk to Ms. Booth and she tells me something completely different than the report, that's my understanding, right?
Okay.
Yes.
Got it. All right. Mr. Apt, why should the photo lineup be excluded and her, meaning Ms. Booth's identification made through the photo lineup. And then finally, because there's always this piece, if I exclude it, should she still be able to attempt to identify your client as the person associated with 339 via an in-court identification?
Those are excellent questions, Your Honor, and I would ask the court to exclude both. And the first point I'd like to make is that the state chose not to call Ms. Booth here today to come testify about the level of certainty, accuracy, confidence, misidentification. All of those things could have been cleared up by the state by putting Ms. Booth on the stand. They chose not to call her. I don't have the burden of production here. That is, there's a totality of the evidence standard that applies in these cases. I'm fairly certain the court is familiar with Simmons versus United States and the two-pronged test. The first, but I'll put it on the record just in case. First inquiry the court makes is whether the photographic display was impermissibly suggestive. Only if it was, then the court reaches the second question, whether there was a very substantial likelihood of irreparable misidentification.
So let's focus on that first one, because I'm not feeling that the process was impermissibly suggestive. So we don't even need to get to number two. Tell me where the impermissibly suggestive activity occurred.
Sure. Well, we don't know, because the court has to look at a totality of the circumstances, and we don't have Ms. Booth here. We don't have the other detective here. And in the cases that define what's impermissibly suggestive, there are many cases which detail the factors the court is to look at to determine impermissibly subjective. And I cite those in my brief: Biggers, Glass, and Beals. Biggers is, I believe, a U.S. Supreme Court case, and then Glass and Beals are Georgia cases. And there are 5 factors the court is to look at. And that's why I asked her particular questions about whether it was impermissibly suggestive. I asked her about the opportunity of the witness to view what length of time the witness had to view this particular defendant at the time of the alleged identification. She had no knowledge of that. The degree of attention is the second factor. She had no knowledge of that. The accuracy of the prior description by the witness. Detective or Lieutenant Moss, had no knowledge of that. The level of certainty by the witness at the time of the confrontation. The witness had no knowledge of that. And the length of time between the alleged identification and the lineup, and the witness had no knowledge of that. The witness that the state presented had no knowledge of any of the 5 factors that the court is supposed to look at in determining whether there was an impermissibly suggestive identification. And I don't have the burden of production, they do, and they couldn't establish any of those 5 factors that the court is supposed to look at. And so for that reason, I believe the photo lineup at the under the totality of circumstances, they haven't met any of those 5 prongs of the test. And so there's no evidence to suggest that to this honorable court that there is anything that is supporting the objectivity or reliability of that evidence. All that Detective Moss can testify to is that she showed her that she wasn't even the one who picked out the photos. So we have no idea where the photos came from, whether they were impermissibly suggestive based on who was chosen, how they were chosen, whether they were chosen based on race or other hair or eye color or other factors, because she wasn't the one who chose the photos. She can't testify to any of those important factors that the court is supposed to look at and evaluate. And so as a result, I would ask that the lineup be excluded. I would further ask that the court exclude her identifying my client at trial, which is the court is inquiring about, because of the arguments I cite in my motion as to both accuracy and confidence of the witness. Again, the state had every opportunity to subpoena Ms. Booth here to court today to be able to testify about those issues and chose not to. And so I am arguing to this honorable court that de facto, this is impermissibly suggestive because there's no evidence under Parker versus State, under Glass, that allows this court to evaluate that test that it is required to do so in order to ensure that my client's due process and confrontation clause rights are not violated. Thank you.
You're welcome. Mr. Fawcett, your thoughts about the admissibility of the photo identification and how that spills over into a separate in-court identification, should you seek to do that?
Well, I think the issue is the same. I mean, partially, I thought that counsel was going to make a different argument about one of the defendant's friends that he was talking to, but I think the same argument applies as it relates to Ms. Booth. So we're talking about someone who is connecting this particular defendant to room 339, not necessarily I saw this person commit a crime, person who was employed at the hotel, and just by the testimony and what came out in facts, has the opportunity to observe this particular person on multiple occasions. So I would present to the court, State versus Harris, Supreme Court, 316, Georgia, 272. It's a 2023 case. It speaks to witnesses that are acquainted or otherwise familiar with a particular person of interest. It simply states that if the witness was acquainted or otherwise personally familiar with the suspect before making an out-of-court identification, there is not a substantial likelihood of misidentification regardless of an impermissibly suggested procedure. Rather, the use of photographs under such circumstances functionally serves the purpose of confirming the suspect's identity. Now, I'm not solely relying on that. I'm citing that because I think the facts came out to where Ms. Booth was in a position to see this particular defendant, Mr. Charles, associated with that room on multiple occasions, particularly since he lived at that location and resided there, and she worked there on a full-time basis. The other thing is just looking at the photographs themselves. It doesn't matter who prepared them, the characteristics of the persons depicted, the age, the race, tattoos, facial hair, clothing, colors on the photographs, anything where you could look at the photographs themselves and say, hey, this person sticks out as someone who they might be trying to point to. I would submit to the court that those photographs, there's nothing special about any one particular photograph. And when Ms. Booth wrote out that statement, whether she saw the person commit the crime or not, but that statement is one of affirmation. It is a statement of certainty. And I think it reflects whether she heard the person killed it. She's trying to identify the person she sees associated on a regular basis with that room. And to the extent that the court heard the manner in which the procedure was administered by Lieutenant Moss, she went to the person's place of employment. I would submit that that's probably a place where she's going to be more comfortable than a police station in a conference room. There was no testimony of any threats or promises made by the detective. She read the admonition, and there was no indication noted that Ms. Booth did not appear certain as to who she was trying to point law enforcement out. I would submit simply this to the court. On its face, those photographs do not appear to be impermissibly suggestive, and that is the first prong that the court has to determine. If it isn't impermissibly suggestive, the inquiry stops there. If it is impermissibly suggestive, then typically, it's been my experience, I would ask the court for an opportunity to bring in Detective Alexander from out of town, he's in Texas, and to bring Ms. Booth in. But typically, I would ask the court to make a determination on that first prong. I don't believe the defense has established it. I'm asking the court to deny the defendant's motion to suppress identification.
Detective Alexander is out of town now, or he now lives and works in Texas?
Lives and works in Texas.
Got it. Okay.
All right.
Thank you.
Could I just briefly respond, Your Honor?
Yes, you were pretty brief with when you said you were going to be brief with the recross, so you're on a roll today.
Thanks. Well, so, with all due respect to Mr. Fawcett, he's relying on a case that says, the witness confirming the identity of the individual satisfies the due process prong. And I guess that's my point. Had the witness come today, then the court could make that evaluation. Had the state brought Detective Alexander today, then the court could have made the evaluation of the 5 prongs to determine if this was impermissibly suggestive or not. And my motion doesn't just address the first prong, it addresses both prongs. And the court, you know, they have the burden of production. It's not my burden. And so then Mr. Fawcett proffers to this court what Ms. Booth did or didn't see. And that's a proffer. That's not Ms. Booth coming to court and saying that identification is accurate, that identification is reliable, that identification is permissible. And so I would ask the court to suppress this evidence.
Got it. All right. I will take this under advisement and get a ruling out shortly. Let me see where we are with this case. We need to get it on a trial calendar soon because it's an old case, but we were on pause for a little while because Mr. App was unavailable. So we will try to kick it back into high gear, but I need to rule on this first so people know. I will say, I don't know that my ruling on this is going to say, oh, now we got to work the case out or we've got to fold, because it doesn't sound like any of these 3 says, I saw Mr. Charles shoot Mr. Braswell. That's just not the way the evidence broke for the state. The most positive identification would just be Mr. Charles is associated with a hotel room. And Ms. Ballou, the things she said are of great interest to the state's investigation, but I don't know that the jurors would ever hear what she said about what she heard. And then Ms. White says, look, there's this guy, and she described someone who parts of the description seem to fit with Mr. Charles and part of them don't. But I will assess all 3 and get a ruling on all 3. But I flag all that saying that the identification is a little peripheral. It's not head on. I saw the shooting and the guy running from the scene saying, I just killed Bulldog. I identify as Mr. Charles. So I don't see the ruling as being dispositive in this case, but you're entitled to it. So I'll get it. And then we will try to get this case on an upcoming calendar. So it can either resolve short of trial or a jury can resolve it. Mr. Fawcett, any discovery issues you're aware of in this case? Oh, we've been waiting on the crime lab or anything like that? Or is this case otherwise, assuming you get your witnesses subpoenaed, trial ready?
It's ready.
Okay.
I don't think any issues.
All right, Mr. App, same question. You're not aware of any, hopefully you would have flagged it a while ago saying, where's the DNA?
It's ready for trial.
Okay, so we need a ruling and we need a trial calendar. And Mr. Charles, you live in New York.
Right.
Okay, so your lawyer has done a good job of making sure you only have to come down here when you absolutely have to come down here. The way trial calendars work in my division is there's a day where we call the calendar, and then we start trial usually the Monday after. So we call it on a Wednesday or a Thursday. Let's just be in communication about whether Mr. Charles would need to be here for the call of the calendar. If it's resolving that day, of course he needs to be here. But if you know it's going to be a trial and we've talked about, hey, it's going to be the second week of the trial calendar, I'm not going to insist on Mr. Charles coming down here for the call of the calendar unless you want him here, and then I'm happy to insist on it.
I would like him excused, or he could appear virtually.
He'd need to appear virtually so he could hear what's going on. Like, hey, we're second out on the first week or something like that. But in terms of in person, today made sense, and it's been a minute. And certainly for the trial, but for the call of the calendar, I will be all right with a virtual appearance. Again, unless that's the day this case is somehow resolving.
We appreciate that. Thank you, Your Honor.
All right. If there's nothing else from the state or the defense, we'll call it a wrap on State versus Charles for today.
Your Honor, could I have a moment or two
To find Mr. Twitchell?
to find Mr. Twitchell, his family, his supporters, and then also briefly talk to Mr. Abak?
You may. I may sit right here while you do it, but go for it.
do you want me to go outside?
Yeah.
Oh, he's here.
It's good. Let's see.
I will get you the photo lineup when I'm done with the motion.
Cannabis, cocaine. And people out. Okay, well, let's result in the lab where there were no results. They were, we don't get out.
Really?
And,
Full house. Okay. This is the time to do that.
Results, meaning there were no.
Didn't test for those.
The results of a lab were complete or listed in the toxicology section. But there leads to no results.
There were no results because if they weren't tested for, if they were tested for, it's like positive or negative. I called them.
Okay, well, I mean,
It's like a change file.
services. That's good forms, thrift, all stuff, sickness.
Okay.
I cause that isn't getting you for I.
Well, no, I'm happy to really possible. No, I mean, it's the same.
He's claiming that now there's, it says no result. It seems odd that they're literally level. His blood.
It was not asked. The doctor did not check the box. The test was over.
I'll come back out in a little bit. Okay.
Well, it is what it is.
I'm gonna say it's just.
Um. Alright. Or you get to sit up here. Yeah. Where is my? That's what I'm looking for. Okay. Is there paperwork we have to do?
Not here, no.
Okay.
We don't do any at all.
Are you just gonna call?
I am gonna do that at the end when we are gonna do the statement as well.
Yeah.
Yeah.
I just.
None.
You sound like the problem.
A lot of it was not, no. But they have done working double shifts and, I mean, yeah.
Just need a few hours out.
Come back, I promise.
You kind of took that last time, right? Okay, focus on what I'm saying. Okay. Yeah, it's just, you know, I know that it's just. You are engaged. You're not. Just, do you want me to call her your fiance or not? Do not. Yeah, just I think just apologize again to yeah, okay. This was at 39. Can you double check the? That's 35 miles an hour. And he was doing between 76 and 82. According to this, she said 58. He was doing 58. According to Jennifer's discovery summary, but I'll check the. Where's mom? Yeah, I was about to say.
Where's Mama? Hey, try.
He's outside. Goodness, dude. This is his pre-crash data.
What made Jennifer put that other?
I don't know, maybe she was looking at the,
This doesn't help me. What this?
that's his pre-crash data. So the numbers on the very top row, that's his speed. And do you have his list of injuries, Jay?
Oh, I do. Isn't it?
Yes.
I've got a pretty thorough list. Okay. That's it, not wrong.
questions. As well. Yes, if you understand that you're trying to draw my jury. And you're giving up that right. No, voluntarily. Yes, they're your course. You like. Oh, that jury trial. That's. Witnesses and evidence against you. I'm going to present witnesses and evidence against you. Yes, but that you're retaining a few guidelines for high school events. 30 days to file a sheriff plea. Judgment. Alleging something. This is I've announced the stress. I'm changing my life. I can't do it before. That's a very tough one. I mean, it's like I wish I had this. Because I'm a big fan. But it's when you're, I imagine.
You may see, welcome to order.
Mr. Apt, are we ready?
We are, Your Honor.
Okay. Let's get on the record then. Ms. Rivers, are you ready? This is 25 SC 002653, State versus Twitchell. Mr. Body is here for the state. Mr. Apt is here for Mr. Twitchell, who is here in court. Good morning, Mr. Twitchell. Mr. Apt, my understanding is that we are here for a non-negotiated plea in lieu of trial in Mr. Twitchell's case. Is that the case?
100% accurate.
All right. Then I'm going to ask you and Mr. Twitchell to be up at the podium for at least the plea part. When we get to sentencing, that may be so Mr. Twitchell's in front of the screen. You're at the podium, the lectern part. When we get to the sentencing piece, if that's more involved, I'll note for the record, there are many, many people in court. It may make sense for you to retire back to defense counsel's desk, but we'll see how that works. Mr. Twitchell, in just a moment, Mr. Abadi is going to put you under oath and then ask you a series of questions about your case and your rights as a criminal defendant. You need to answer all his questions truthfully and completely. If at any point during the discussion that we're all going to have, because your lawyer is going to have some things to say, I'll have some questions. If at any point you have questions, or we start talking about something that doesn't make sense or is going differently than what you and Mr. Apt had discussed, I need you to stop us and let me know. I want to talk with my lawyer for a second, or you may just ask me, what's that Latin word someone just used? And if I know, I'll tell you, but we'll work through that. But I need you to let me know if you have a question. Will you do that?
Yes.
Okay. Mr. Body, when you're ready.
Raise your right hand. You solemnly swear and affirm testimony about giving the matter pending before this court with the truth, the whole truth, nothing but the truth, sir.
Yes.
Put your hand down. Could you please state your true, correct legal name for the record?
Nevada Twitchell.
And sir, are you at this time taking under the influence of any alcohol, drugs, or medicine?
No.
Any medication that you take on a daily basis or regularly that you didn't take today that would affect your ability to understand why you're here this morning?
No.
How old are you, sir, and how far do you go in school?
28, and I'm currently in college right now.
Are you able to read, write, and understand the English language?
Yes,
And do you understand that you are charged in this indictment with one count of homicide by vehicle in the first degree, count two is homicide by vehicle in the first degree, and count three, reckless driving, which is misdemeanor, and count four, which is also misdemeanor failure to maintain lane.
yes,
Do you understand you have the right to be either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive jury trial.
yes,
And have you had enough time to discuss the facts or against the case with your attorney, Mr. App?
yes, I have.
And are you satisfied with the services provided?
Yes,
And counsel, do you waive formal reading of the indictment?
we do.
Well as any and all defects in the indictment, including any disrespect
We
to
do.
your client's name for the purpose of this plea.
We do.
And Mr. Twitchell, has your attorney advised the minimum and maximum sentence for each charge you're pleading guilty to?
Yes,
Did he advise for count one, homicide by vehicle, minimum is 3 years and maximum is 15 years?
yes,
Did he advise for count two, homicide by vehicle in the first degree, saying minimum 3 years, saying maximum 15 years?
yes,
And then counts three and four, which are the reckless driving and failure to maintain lane. Those are both misdemeanors, but the minimum is 1 day, and maximum is 12 months.
They can all be subject.
Mhm.
Answer yes.
yes.
Do you have any questions about the minimum or maximum sentences for each of the counts you're pleading guilty to?
No, I do not.
Correct. Do you understand that this is a non-negotiated plea of guilty, which means that the state will make a recommendation to the court, and your counsel will have an opportunity to make a recommendation to the court and provide any mitigating evidence. The court isn't bound by states or your counsel's recommendation, and he can sentence you as he sees fit and run each count you're pleading guilty to consecutively or one after another.
Yes, I understand.
You understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal court, sir?
Yes,
And you understand that if you are not a United States citizen, the guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anyone else.
yes,
Do you understand by pleading guilty, you're giving up the following rights: the right to trial by jury, the right to remain silent, not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you before the point if you were unable to afford an attorney, the trial of your case, the right to remain silent, not incriminate, the right to presumption of innocence, and right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charge against you proved beyond a reasonable doubt by the state of Georgia, and then the right to appeal if convicted or be charged after trial. I understand that you are giving up or waiving all of the rights I just read to you.
yes, I do.
Do you have any questions about any of the rights that I just read to you that you are waiving and giving up?
No, I don't have any questions.
And Mr. Twitchell, if anyone forced, threatened, or promised you anything to get you to enter this guilty plea here today, sir?
No.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes,
And you plead, Your Honor, I apologize. What's the case number for this case? Do you happen to have that?
I do. It's 25 SC 002 653.
Mr. Twitchell, how do you plead in indictment number 25 SC 0002453, count one, homicide by vehicle in the first degree?
guilty.
And how,
Excuse me, 453 or 653?
653.
oh, I'm thinking about. How do you plead to count two, and I'm sorry, the case in 25 SC 002 653, count two is homicide by vehicle in the first degree?
Guilty.
And then how do you plead to count three, which is reckless driving?
Guilty.
Then the last count in the indictment is count four, failure to maintain lane. How do you plead, sir?
Guilty.
And Mr. Twitchell, is this guilty plea freely and voluntarily given with full knowledge of the charges against you, sir?
Yes,
And do you understand that you may only have a limited right to appeal this guilty plea conviction?
yes, I understand.
You also understand you have 30 days from today to file a direct appeal from this guilty plea.
Yes,
And you have until the end of the term of this court, or 30 days, whichever is longer, as it relates to filing a motion seeking to withdraw this guilty plea.
Yes, I
If there's
understand.
any questions about those rights that I just read?
No.
And then do you understand you have only 4 years from today for a felony charge, 12 months from today for a misdemeanor charge, to file a habeas corpus petition challenging this guilty plea?
Yes.
If you have any questions about the steps that need to be taken in accordance with a petition for habeas corpus?
No. Sorry.
Your Honor, having this case proceeded to trial, please state what has been able to prove beyond a reasonable doubt that on February 19th of 2024 at approximately 2:15 a.m., the defendant was driving his Subaru in Impreza in the area of Hamilton E. Holmes, the intersection of Baker Ridge Drive here in Atlanta, Georgia, Fulton County. What the evidence would show is that the defendant was driving at a high rate of speed, and in his effort to negotiate a curve in the road at a high rate of speed, he ended up striking the victim in this case, was Tamika Gray, who was driving a Dodge Avenger head on, causing a pretty serious collision, leading to the death of Miss Tamika Gray and her unborn child. She was approximately 8 months pregnant at the time of the accident that occurred. Upon the collision, 911 was called, and members of the City of Atlanta Police Department did arrive. The lead investigator, Andrew Hatfield, did an investigation on scene and obviously did search warrants related to the crash data retrieval or crash data information from what I call the black box for each of the vehicles. In doing so, he was able to see that 5 seconds prior to the collision, the defendant was driving 93 miles per hour. At the point of impact, he was driving 83 miles per hour when he struck Miss Gray. And Miss Gray was traveling just prior to the incident, 36 miles per hour. And the speed limit in that area was 35 miles per hour, which she was basically traveling at the time and she was struck head on.
So Ms. Gray was driving, did you say Charger or Avenger? Avenger. She was a passenger in the Avenger or she was driving the Avenger? Driving Avenger, pregnant at the time, and it was a fatal impact for her and her unborn child.
She was on her way home from work. She's a medical professional and was driving home from work at the time that she was driving.
What about, and maybe you were going to get to this, where was she fully in her lane and Mr. Twitchell you mentioned he couldn't maintain his lane because clearly he was going too fast for the road when he entered a turn and ended up striking Ms. Gray's car.
Yes, the evidence from the investigation would show that Ms. Twitchell was traveling within her lane, the defendant, because of the high rate of speed and his inability to maneuver as he was attempting to maneuver the curve, traveling in her lane and struck her head on.
Okay.
That's what the state would have been able to prove beyond a reasonable doubt in this case. I've gone to trial, Your Honor. Relates to the defendant's criminal history. He has no felony arrest, any arrest at all, to be perfectly frank for the state's recommendation. As it relates to count 1, is 15 years to serve. As it relates to count 2, it's 15 years to serve, but concurrent with count 1. And then counts 3 and 4 would merge with count 1 homicide that day.
Okay.
Miss Tamika Gray's mother, Elizabeth McBurney, she may be on the Zoom. She's been here on multiple occasions. She might not be today.
Not on the Zoom.
Okay.
I don't know if your victim advocate wants to reach out to her. Okay. On purpose?
No, she said she's not getting my link. I didn't send her the link. She said she's not, I just sent her, she said she hasn't received it.
Okay. So she's saying she got no link, not that, I want to make sure we didn't give you a faulty link. She's saying whatever you're trying to send, I'm not receiving. Okay. Is there something we could email her, or is that what you're doing is emailing her?
Just communicating, because she said she hadn't received it either, still, so that's what she just sent me.
what I
I
can
don't
do.
know why it's not going through.
Okay,
I can attempt to, during the defense presentation, I can attempt to, present or text her Zoom link, see if she can get on that way.
great.
For whatever reason, she can't. What I can tell you the court, that she's expressed to me is she wanted the maximum, which was 30 years to serve. I didn't feel that was appropriate, obviously, due to the lack of criminal history of this defendant. But I understand the serious nature of how this has impacted her family. She lost a daughter and a grandchild. Miss Gray's uncle is also here in court, Sterling Gray. I wanted to look forward to he is present. I don't believe he wants to address the court, but I just wanted to know that she has family support here in Atlanta here as well.
Okay, and can you tell me a little more about her? You said she's a medical professional. Did she have other kids, or this was going to be her first child?
I don't.
If you don't know, don't say things you don't know. Okay. All right, great. Are you Mr. Gray? And you don't have to say anything at all. I just want to make sure if there is something you wanted me to hear, that you have an opportunity to be heard.
I just don't know what my sister said.
Okay, well, we're going to try to get her onto the Zoom so she can be heard, see if we can work through those technical difficulties.
How are you doing?
Thank you for being here. All right, Mr. Apt.
Your Honor, I have a lot to unpack for the court. May we go, as Your Honor suggested, back to counsel table, or can at least Mr. Twitchell for now sit at the
Yes,
table?
but I got a couple questions for you, Mr. Twitchell. First, were you injured as a result of this?
Severely.
Yes.
I asked Mr. Twitchell. Tell me what happened to you.
I mean, I was taken to the hospital right away. I had broken my ankle pretty severely, a couple other bones throughout my body, and then I had internal bleeding that resulted in, emergency surgery and removal of part of my colon. So
Removal of part of your ankle?
my colon.
Your colon.
So-
Okay, so you had internal injuries and some bones broke.
Yes, I was basically like impaled by the steering wheel.
Okay. So you're not the one who called 911?
No, maybe the OnStar, but I'm not sure.
Okay. You weren't in a position to do something like that?
No.
Okay. That's all I have for now. For you, Mr. Apt?
Sorry, Your Honor. I apologize for interrupting.
No, it's good. So now so take a seat, Mr. Twitchell. It may be that you come back up. Mr. Apt is gonna, he's thought through this. So there may be a time when you say something, there may not. You've got an absolute right to be heard, just like Ms. Gray's family does. Beyond that, it's my discretion. I see a lot of people here. I will not be hearing from every one of them. But hopefully there'll be a representative sample of people who've got good things to say about you. And Mr. Apt's gonna manage that process, but know that there'll come a point when, if he doesn't, I will say, Mr. Twitchell, is there anything you want to say? But he may want that to be towards the end, and that's his call. So if you'll take a seat next to the paralegal, I will turn it over to Mr. Apt.
Thank you, Your Honor. Before you, as you heard, is Nevada Twitchell. He's 28 years old. And Mr. Abate is absolutely correct in so much that he has no criminal history. He has no prior speeding tickets, Your Honor, no traffic violations. And there's a reason for that, and I'll get to it. But it's important Your Honor knows that up front. Mr. Twitchell has had a complicated life, a fantastic life in some regards and complicated in others. His father died when he was 13. And so he knows what it's like to lose a family member. He knows what it's like to lose a parent. And so it adds levels of his remorse, which I think you'll hear about. Mr. Twitchell attended Roswell High School. He was in the marching band. He played saxophone there successfully. He did a whole lot of extracurricular and academic things in high school. I'm not going to belabor those, but one of the things he did is he started an anti-bullying club at Roswell High School. That's the kind of person that Mr. Twitchell is. He's the kind of person who cares about other individuals and what happens to them and how they feel and what they do in life and how he makes an impact on other people's lives. He graduated from Roswell High School and then attended Kennesaw State for a year. But what he realized a year into college was that his real passion, Your Honor, was cooking, was the culinary world. And so he left Kennesaw State to take a job in Europe, working and studying as a chef and making olive oil. And he essentially was on the job training, doing that so that he could come back to Atlanta and join the restaurant industry. And he worked his way, then he came back to Atlanta after working in Europe and worked his way up in the culinary world. He started, I don't know if Your Honor's a foodie, but I am. And he started at a restaurant called Lila in Midtown that's owned by a pretty prominent chef named Craig Richards. He worked for Chef Richards at Lila and then for a number of years. And then he got essentially a promotion to work at another prominent restaurant called Lazy Betty. And he worked there successfully until he got promoted again to another restaurant called Atlas, which is in the St. Regis Hotel in Buckhead, where he was working as a chef at the time of this horrible incident. He was what's called a lead line chef, which is an important position in preparing and cooking food at a top restaurant. Atlas is a Michelin-starred restaurant, if that means anything to the court.
I've heard of it.
So you're obviously aware that there are a tremendous amount of friends and family here. Your Honor is correct. You're not going to hear from all of them. You're going to hear from a few of them. After this incident, obviously, because of his bond and ankle monitor, Mr. Twitchell could not continue working, but he had not decided just to sit at home and do nothing. He enrolled in college again and is currently a full-time student online at Chattahoochee Tech. And so he is in school, studying, and doing the best he can under the circumstances. There is an ongoing multi-million-dollar civil lawsuit, which is a parallel track to this case, Your Honor. I know that's not truly of the court's concern, but I sometimes think it's important to just point that out so that the court knows that in terms of whatever it means, there's a lot of insurance involved, and there's ultimately going to be some financial restitution there. They're kind of waiting on this case to resolve before they settle that case.
So you may know the answer in case I end up not hearing from Ms. Gray's mother. Was it the mother we're trying to get on?
Yeah.
Did Ms. Gray have other children? Since you know about the civil suit, I'm seeing uncle says two other kids.
I don't want to make an absolute representation. Courts, my understanding, she did not. This was her first child.
Okay.
That's my understanding.
All right. Uncle says she's got two other kids.
Then, I mean,
I'm just thinking through the lawsuit and the estate, and so
Sure.
could be, all right.
Sure.
Okay.
So, and you know, honestly, I don't want to make a misrepresentation of court, but if the uncle says so, then I would rely on that.
Me too.
Mr. Twitchell had, as you heard, significant injuries from this case. He did have internal bleeding. His colon and intestines needed to be rebuilt and resected. Both lungs were collapsed for Mr. Twitchell. He shattered his right ankle, and that now has screws and plates. His right knee was shattered.
Was he wearing a seatbelt?
He was wearing his seatbelt. He had multiple foot fractures. His right hand had multiple fractures. His right clavicle was broken, and he's got 4 spinal fractures as well that occurred. So all kinds of bones broken all over his body, internal bleeding, colon had to be partially removed. It was very serious. There is no evidence of any drugs or alcohol in this case. There are records from Grady for Mr. Twitchell, and I think they're a little problematic because up until a few moments ago, based on the records we had, Mr. Twitchell, in the 160 hours prior to this incident, it says 168 hours that they measure for, there was no alcohol, no cocaine, no benzos, no THC, no barbiturate, no drugs or alcohol of any kind. I think Mr. Abate is going to proffer to the court that he's spoken with Grady and that they are saying they never tested for any of those items. I find that shocking in a case like this, but the records themselves say that there's a 168-hour period they tested for, and that none of those drugs or alcohol were found.
Let's assume you're correct, that they tested for it and it's a negative, as opposed to they didn't test, which is why it shows negative.
Right.
How does it make it better that your client was sober going 93 miles an hour in a 35? Let's get there.
Okay, he fell asleep at the wheel, Your Honor. And we had hired our own expert who is here today, who would testify that there is a significant amount of evidence he fell asleep at the wheel. I want to walk you through the 24 hours prior to this accident, what happened and what Mr. Twitchell was doing. He had gotten back from a short vacation and went back to work at Atlas and had to work essentially a double shift over 2 days. He worked from 3 p.m. to midnight on Friday, and then on Saturday he worked from 8 a.m. So he goes home at midnight Friday night. He gets up Saturday morning. He has to be at Atlas at 8 a.m. He works from 8 a.m. to midnight on Saturday night. Then on Sunday, he works from 8 a.m. until 6:30 p.m. on Sunday. And then Sunday, he goes off-site to do a private dinner where he has to cook from 6:30 p.m. to midnight. And so he's basically working nonstop all weekend. And then at midnight, Sunday night, he's, after the dinner, he's on his way home.
This private dinner, is that meaning this is a personal contract that Mr. Twitchell had, or this was the boss at Atlas saying you have to go to this house and do your work at someone's house, but it's Atlas and I'm telling you, you need to do it?
Your Honor, it was personal.
It was
for
an
a private endeavor.
You chose, after working so hard all these other days, to extend your work day on Sunday, not your boss.
Not for that, no.
That's correct.
What's not for that? Either you decided to do this dinner on Sunday or your boss did.
He did not decide that.
You decided after these hours that were so extensive and left you so tired to, on the side, do something that you arranged, not that you had to do or you would lose your job.
That's correct. That's
Okay.
correct, John. That's correct. He worked too many hours and he fell asleep at the wheel. And the evidence, there's not just Mr. Twitchell's testimony of that. We would hope the court would believe that given the lack of drugs or alcohol, but there is also a lot of scientific evidence of it. We retained an expert named Ron Tomlin, who's here today if your honor wants to hear from him. But Mr. Tomlin has 20 years of law enforcement experience and is an forensic accident reconstruction expert. There were no skid marks at the scene. There was no evidence in the black box of Mr. Twitchell braking. And he is going into a turn, and instead of making the turn, he just crosses over into the opposite lane of traffic. And the tires show, from tire indications from both the road and the black box show what's called drifting, which essentially the rolling tire marks indicate that tends to suggest someone is asleep at the wheel. In addition, he's going from a very low rate of speed 5 seconds prior to the accident to essentially hammering down on the accelerator at 100%, which tends to suggest he's fallen asleep and his foot hits the wrong pedal and he accelerates the car. He's at 82 miles an hour at the time of impact, Your Honor. It is entirely suggestive that this is not the result of and should not be treated the same way, I hope, as someone who has voluntarily consumed intoxicants. This is someone who chose to work and was overtired.
And then chose to drive. In the era of Uber and Lyft and mom or dad or brother, or not dad, but someone to get them home.
All of that is true and is why we are pleading guilty.
Okay.
We have a number of people that we want Your Honor to hear from, including Mr. Twitchell himself, Your Honor. Just want to go over a few, just make sure I'm not missing anything. Yeah, in the 5 seconds prior to impact, Your Honor, the accelerator on Mr. Twitchell's car went from 5% to 100%. The sentence I am going to ask Your Honor for is, I acknowledge, somewhat extraordinary. And Your Honor is absolutely correct. He's pled guilty. He's pleading guilty. He could have just slept it off or called an Uber. There's lots of things he could have done. But I think it's a markedly different case. His criminal history, his life, what he's done with his life, and the circumstances of this are different than someone who is out partying, doing drugs or alcohol. And so I am asking the court humbly to consider a 20-year sentence with first offender treatment and have the first 5 years on house arrest. And Mr. Twitchell could be on an ankle monitor. We would only ask that he be allowed to leave for community service, church, and some family functions. We would suggest to the court that we would ask the court to sentence and voluntarily surrender his driving privileges for 10 years. So the first 10 years of probation, he would have no driving. We would ask the court to sentence him to 1,000 hours of community service. And since it's theoretically possible, we are waiving, just to make it clear what we're asking for, we're waiving the bid date in this case, Your Honor. So we're not asking the court to sentence him to 20 years first offender and then coming back in 3 years and saying, we want probation to terminate. We're asking for a legitimate 20-year sentence with the first 5 years really locked down on house arrest with no driving for a decade and 1,000 hours of community service and waiving the bid date. And I realize that I'm not supposed to be objective and I'm not objective, but this case to me feels different, a lot different than a lot of other vehicular homicides I've handled. And so I am asking the court to really think about whether or not to incarcerate Mr. Twitchell. I don't know that state prison is the right place for him. And the heavy weighs the crown for the court to decide whether he belongs in a state prison or not. But it's my job to argue that he doesn't. And I don't believe he does. And I've gotten to know him and his family very, very well. Your Honor can see the army of people. Just stand out if you're here in support of Mr. Twitchell. It's all these people, Your Honor. And they're here on his you can sit down, thank you. They're here on his very worst day. They're not here for a graduation or a communion or some great event. These are the people who are willing to take off work and school and whatever else they've got going on in their lives to come and support Mr. Twitchell on the worst day of his life, not on the best day. And there's a lot of them. I do want Your Honor to hear from some of them, a few. So the first person I would ask, does Your Honor want me to swear them in?
No.
Okay.
Nope, they can just need to be at a microphone, and so it's probably can they just come up and stand by Mr. App? Yeah, so in any order you want, and they'll just come stand next to you just as Mr. Twitchell did.
So I'm going to call his stepfather, Scott Pullen, up here first.
Just come all the way up, exactly, then in front of Mr. Twitchell and to the podium. And if you could spell your name, because we've got to get it in the record, and then anything you want to share. And for each of you, if you're going to read something, which is fine, read slowly, because the court reporter needs to take down everything you say. So please read slowly.
Will do. My name is Scott Tulloch, SCOTT-TULLOCH.
Thank you for being here, Mr. Tulloch.
Shall I proceed?
Go ahead, please.
As I mentioned, my name is Scott Tulloch. I'm Nevada's stepfather. I've known Nevada since he was 10 years old. I've watched him develop into a caring, compassionate, and loving young man. He is creative, funny, and hardworking. He dreams big, is curious, and sees the best in others. He is kind, expressive, and talented. He picked up his first instrument in elementary school and found his people when he discovered marching band. His creativity continued to flourish as he found cooking, which has taken him from being in charge of making cowboy beans on our family camping trips into some of the best restaurants in Atlanta. I have seen him struggle to find his place and have rejoiced as he found his passion and purpose. Through it all, he was taught to treat others with compassion and respect and take responsibility for his actions. Nevada has faced challenges and pain along his journey. As Mr. App had mentioned, he lost his father to suicide when he was 13. He knows firsthand the hurt of losing a parent at a young age. He has worked hard to understand and overcome these challenges while continuing to look ahead forward to a future yet determined. As a parent, I could not be more proud of his journey and for the man he has become and will continue to be. The events of February 19, 2024 have changed our lives forever. We all lost something that day. We mourn for those lost and pray that their family find peace. We pray for Nevada and wish that there is light beyond this moment for him. I have seen the physical and emotional scars Nevada carries with him that serve as a constant reminder of reminder of that day and every day since, excuse me. I have witnessed a tremendous burden, this accident, and feel the relenting weight on his shoulders and our family every day. This was a tragic accident, but it was just that, an accident. I know that if Nevada could change what happened, he would. Nevada would never intentionally hurt anyone. Nevada is a different person today. He will be forever changed. Nevada will continue to evolve and reinvent himself as he continues to learn, grow, and gain perspective from this experience. We ask the court to allow Nevada to continue on this journey to discover how he can best support and serve his community. Thank you.
Thank you, sir, for being here and for stepping into Mr. Twitchell's life when you did.
Your Honor, next I would call his mother, Nina.
Good afternoon. My name is Nina Perea, Nina Perea. I'm Nevada's mother. I wrote something short to describe my son. It's going to be a little embarrassing for him, but it's actually one of the first things I thought of. Who is Nevada? I got an accurate sense of who Nevada was and what his personality would likely be when he was in kindergarten. His teacher called me to come into the classroom after school for a special unscheduled parent-teacher meeting. When I arrived at the classroom, she walked me over to the carpeted play area. She pointed to what Nevada had built using wooden building blocks. It was massive and striking resemblance of a character from a popular TV series the kids were watching at the time. It was a giant transformer robot. It was about 6 feet tall. She told me that in her 20-year career as a teacher, she had never seen anything this complex done by a student of his age. The robot had created a buzz And the other teachers brought in the other students from the neighboring classes to marvel at the structure. What impressed teachers more than anything he had built, and the most meaningful to everyone at the school, is what Nevada did afterward. At each of the class viewings, Nevada carefully unassembled the structure piece by piece and gave a tutorial to the children on how he constructed it. He invited the children to join in on recreating it. It now has become the children's new project, led by Nevada. I would like to say to the Gray family that I think and pray for you often. Mostly during holiday season, when I know you are hurting the most. That's all I have to say. Thank you.
Thank you, Ms. Perea.
Yes.
Your Honor, next, I would like to call Diana Nicosia.
Hi, my name is Diana Nicosia, Diananeculcea. Thank you for allowing me to speak, Your Honor. I am Nevada's partner. For 4 years, we met back in 2022, working in the hospitality industry. And I am also the person who has started to build a life alongside him and knows the truth of who he is and what he has to live with every day. I'm not here to argue facts, but I want to speak about his heart and his character and who he is as a person and the man behind who you guys see here today. We know that something very unfortunate happened that day in February 19th, something that we may not fully understand exactly what, but it was not a pattern. He does not show a life of recklessness. He lived a single tragic human moment that could happen to any of us and could very well have happened to me as well. This will echo through my life and his life and everybody that loves him for the rest of our lives as well. My heart does break for Miss Gray and her family, as I know that loss is immeasurable. Nevada carries it every single day, and he carries loss as well as from his family and throughout his entire life. He grieves in a way that I know that his words cannot fully hold, and I know that I see it in him. I live with him every day, and he has definitely changed since the moment that we met into who he is today. And if he could take that moment back, he would in a heartbeat. I know for a fact that he is deeply remorseful, and I want to ask for forgiveness on his behalf. I know him as a gentle, warm, and deeply compassionate man. He leads with love in everything that he does. He shows up for people. He showed up for me. When we met, I had a terrible injury myself. I tore my ACL. I couldn't walk for a couple of months, and he was there for me every step of the way. He helps without being asked. He loves being around people and teaching and showing them what to do. And he has always been a source of light in people's lives that know him. I know he did not walk away from this. He almost lost his life. He was in the ICU for almost a month. He was in the hospital for multiple months. He has been recovering for years, and he will still continue to recover and be damaged for the rest of his life. So just unfortunate situation with a good man intersecting in a tragic way. And I ask that you see the whole of him, not just what you see from this accident and in the worst moment of his life. And he's a man that is capable of growth and love and helping his community out. So I know, what we're asking for cannot undo what has been done, but I don't want to take away somebody who has so much good to give and is able to give back and be, here to support the community and support his loved ones. So he's my partner, he's the love of my life, and I, ask for forgiveness on his behalf, and I love you so much. So thank you.
Thank you for being here.
Just one more, Your Honor, before you hear from Mr. Twitchell. We would ask Elizabeth Joffrey.
Good morning, Your Honor. Beth Jeffrey. I'm here for different reasons than I'm usually am in court.
Can you spell your last name for the record?
Geoffroy. Your Honor, I know Nevada because he's friends with both of my children, who both went to Roswell High School. He is the year between my kids, who are 2 years apart. He was a member of the marching band. By the time he got to Roswell, I had been with the band and had been drafted into being in head of all the volunteers, which meant I was at every event, including the band camps, football games, competitions, band concerts. I saw a lot of these kids, and because I was at everything, I got to know them pretty well. Nevada came in, he fit in well with the kids. He was a bright, pleasant kid. He was always in a situation where if Nevada's there, it's going to be okay. The tempers are going to be cooled. The kids are getting along. Nobody's being mean to anybody. He was always that kid. And I saw that through him, but also because I was there so much. I hear what the educators thought of him. I hear what all the other parents thought of him. I hear what all the groups of kids think of him because they all talk too much and don't know who's listening. But he was well thought of, well regarded. He was a good friend to the kids. He was a good guiding person for the new kids coming in, coming up. He was always positive, always helpful, and just always genuine. And he has remained friends, particularly with my oldest child, my son. And I would say this, that your kids get older, but you never stop having to be a parent. You never stop worrying. And, they leave your house and they have other people influencing them. And I just would say, I am happy that Nevada is influenced with my child and that they've grown closer with time. I think that they lead each other in positive directions. I think that he is an introspective, positive person who lifts up everybody around him. And I would just like the court to keep that in consideration when you're sentencing.
Okay.
Thank you.
Thank you. Thank you for being here.
Last, Your Honor, certainly not least, I'd like you to hear from Mr. Twitchell himself.
So before we do that, because I think he is entitled to the last word, it's his sentencing. There is a Ms. McGriff on the Zoom now. Is that Ms. Gray's mother? Okay, Ms. McGriff, if you can hear me, I'm Judge McBurney, and I would very much like to hear from you if you could turn your camera on.
Can you see me?
Yes, ma'am, I can see you. Can you hear me?
Yes, sir, I can.
All right, Ms. McGriff, I appreciate you navigating the technical challenges and joining us. I have already heard from the prosecutor, Mr. Abadi. He shared with me the state's recommendation, and I know that the victim witness advocate was trying to connect with you while that was happening. Since then, I've heard the defense presentation. You've, I think, been on the call for some of it, but I've heard from friends and family members of Mr. Twitchell. He's going to speak in a moment, but if you are interested in sharing with me how you feel and a little bit about your daughter, that would be very helpful to me. But you're not required to say anything at all. I just want to make sure you've got the opportunity to speak on behalf of your daughter and what would have been your grandchild, to let me know what this impact has been on you and your family.
Yes, sir. I definitely would love to speak. My daughter was a shining light to so many people. She was so helpful and kind, always trying to help someone. She was doing the best she could as far as trying to uh, support herself and her children. Um, Everyone who knows her loves her. It's been such a hole left in our family because she's gone and her baby is gone. I understand Mr. Twitchell. Uh, they said he's a good person, this, that, and everything, but the speed that he was going when he hit her was almost 100 miles an hour on the road, not on the highway. There's no way that was the first time. I mean, that's just my opinion. The first time that he was driving at that speed. I don't know if he was impaired or not. However, he is still alive. My daughter and my granddaughter are gone. I could not even see her body. There was nothing left to see, Your Honor. They didn't even realize that she was pregnant. She was about to have the baby. She was 8 months pregnant, Your Honor. I had just left from visiting her 3 weeks earlier. And she's gone. She was my only daughter. I only had 2 children. It is not natural for your child to leave before you do, especially not by something that she had nothing in control of over. I understand that they're hurting, but we have been hurting and will continue to hurt. Like I said, he is still alive. He can still maybe have a family or children of his own. She's gone, Your Honor. She has 2 young children that are still suffering. We are all suffering.
How old are your 2 grandchildren through your daughter?
My oldest granddaughter is 17. She'll be 18 in November, and her son is 16.
Okay. And with whom do they stay now that your daughter passed?
They're with the uncle, his uncle. They were with me, but I have a lot of medical issues, and so that's where they are now.
Okay.
And my granddaughter is, and my grandson, they're just devastated, and we all are devastated. It's there's no way to replace her life or the child's life. She all I can say, she was so happy being pregnant, and we couldn't wait for the baby to come, and to go from that to this is just unbelievable, Your Honor. It's just unbelievable. We just, like I said, she's gone, and it's still hard to believe that she's gone. I'm always waiting on her to call me. She always calls me. Matter of fact, yesterday was my birthday, and I would have been there with her. I actually was moving to Atlanta to be with her and the children. And I'm still waiting on a phone call. You know, she calls me all the time, different times of day and night, and that phone call will never come, Your Honor. And all I can say is that I, I, I understand that they're saying that he's a good person, and he may be, but from our end, there's no way he could be such a good person driving at those speeds. And I'm sure that was not the first time. I understand he was suffering, and he suffered for a long time. She's gone, and my granddaughter is gone. It's just there's not enough words to say how important she was to me and my family. My mother is 93 years old in September. And she would visit with us and the family all the time. And we all miss her so very much, Your Honor. There's nothing that anyone can do to to change anything. But just the fact that it was, it was such a bad accident that I could not even identify her body. I could not even see the vehicle that she was in. There was nothing to see. It was just like she was in a crusher. That's how hard the impact was. And so it's hard to accept it when I didn't even get a chance to see her face again, to hold her hand, to tell her how much I love her. I will never, we will never get over this, Your Honor. Yes, that's all I can say. We'll never get over this.
Ms. McGriff, I appreciate you calling in. I know you've been in court before and you followed this closely. And you're right, you're not going to get over it. Whatever we do here today doesn't bring your daughter back. It doesn't fill in that hole that you've described. But we are taking this situation seriously, as we should. And I will hear from Mr. Twitchell in just a moment. I invite you to stay on the line if you wish. I think your brother is here in court. We'll go forward, but it was very important that I had an opportunity to hear from you. So thank you for opening up and sharing a little bit. I know it's not easy to talk about because it forces you to think about the things that are so very painful in your life. But it was, like I said, important that I hear from you. Thank you.
Thank you for the opportunity, Your Honor.
You're welcome. Mr. Twitchell?
Well. Okay, sorry.
Take your time.
Sorry, that was hearing
It's not
from my
easy.
mom right before this. I mean, I want to take full responsibility for what I did, and I want to ask for forgiveness. I mean, it's not going to change, the loss of life, but I really want to apologize to Miss Gray, her unborn child. I mean, her family's hearing her mother over that call was tough. And I can't understand the grief you're going through. I've known tragedy, but not anything like this. And it's really a tragedy. And I'm incredibly sorry. And sorry, I have this speech. I'm a little lost. Yeah, but I'm here to apologize to everyone, especially Miss Gray's family, her mother, her uncle, her children. Again, I can't even imagine the grief they must be going through. I want to apologize to Your Honor. I want to apologize to the DA. I thank you for having patience. I know this case took a long time to get here. I want to apologize to the first responders that night, the police officers, the paramedics, the firefighters. They saved my life, but hearing about that, I just wish they could have saved her. Yeah, and then finally, I want to apologize to my parents and my girlfriend, everyone who's been here. It's a great honor. This really is like the worst day of my life. And they're here to support me. And my parents, my girlfriend have been supporting me, ever since I've been in the hospital. They were there. And they didn't even tell me about, somebody died when I woke up in the hospital. They had to tell me when I was leaving, and I couldn't even believe it. I don't know. But yeah, but since this incident, I've had time to reflect, really reconsider my life. I mean, I've been going to school, trying to go in a different direction, not that it changes anything, but I'm just committed to making better decisions, changing my lifestyle. But I have to take responsibility. It was my choice to get behind the wheel. And I'm just here to ask for forgiveness and see that my remorse is genuine, Your Honor. Take that into consideration.
Mr. App, anything else?
That's all I have, Your Honor. I appreciate the court's time.
Have you and Mr. Abadi discussed if there is a custodial portion to Mr. Twitchell's sentence, whether the state has a view on turning in later versus going into custody now?
We have not had that conversation. But if the court is so inclined, then I may ask for a very short period of time for him to go in. Again, I stress to the court to consider what I've asked for. I know it's extraordinary, but, and there are other remedies the court could if the court's not so inclined to go with what I've asked for, certainly there are other lesser remedies. PDC is an option. There are other options available to the court. I'm sure the court's aware of all of those.
Yep.
If there is a custodial sentence, I would ask the court just for a brief, minute or two to talk to Mr. Twitchell and his family about a delayed turn-in.
Okay.
Thank you, Your Honor.
You're welcome. Mr. Abadi, do you have what's your thought about a turn-in date as opposed to today?
At the discretion of the court. It's been since this case initiated, I believe, at the discretion of Your Honor.
Okay. All right. So, Mr. Twitchell, you issued a series of apologies as part of the words you shared, and thank you for your words. It's not an easy time for you right now. I'd say this is your second worst day. Probably the worst day was back when this happened, but we are revisiting that now. But you don't need to apologize to me. I'm doing my job. The prosecutor was doing his job, and all those people out there, they're doing their job of being family members and friends. And so you don't owe them an apology. You owe them gratitude and affection, but those are the people who should be here today for you. And it's a good sign for you that you've got that support because you clearly need it. You've been through something difficult. We got to hear from Ms. McGriff how that family has been through something difficult, more permanent, something that will not change after today. They may derive some closure from the fact that you came in and apologized to them. They're the people who should be the recipients of your apology. That Ms. Gray's life and loss of life was something that mattered to the state. Prosecutor took the case, police investigated, and here we are. But in the end, when the dust settles, regardless of what your sentence is, that hole remains in that family. There are two kids who don't have a mom. They're going to graduate from high school next year and the year after. Mom won't be there. You can relate to that in some respects because your biological father left you at a young age. You were blessed to have a replacement. And hopefully that helped you navigate your teenage years. I want you to know, and the people who came to speak on your behalf, that I am not viewing this as you are monodimensional. You were the driver of the Impreza that night in an impaired state. You are much more than that. But it was that series of choices that you made that got you behind the wheel that night in what I'm describing as an impaired state. I don't know what you had in your system, and frankly, it doesn't matter because at a minimum, your lawyer is advocating that you had extreme fatigue, lack of sleep, reasons that would counsel against driving home that night. But you put the key in the ignition, turned it, drove. I don't know how long you'd been driving before this happened. And it's something that you can't unwind now. It's a forever situation. And it's about as bad a forever situation as can be. I don't impute ill intent to you. There's not a villain in this story. This was an accident, but it was an accident that was caused by the decisions you made, what I'm going to call neglectful behavior. The coulda, woulda, shoulda, I need a lift, I need an Uber, something other than driving. And it left this awful, awful impact of the loss of a mother, an expectant mother, the daughter, and now we've learned granddaughter, 93-year-old grandmother who would have loved to have held another great-grandchild. And that great-grandchild was so very close to joining us all, 8 months pregnant. And you didn't know who was in that other car. You may never have seen that other car based on what we're hearing, but none of that shifts responsibility to anyone else on planet Earth. It's your burden, and it's one that you will bear forever. Unlike Ms. McGriff, your mom will get another call from you, lots of calls. And your stepfather and your partner and your friends, they'll all get calls from you and letters from you, and you will be in their lives in an important way. And it sounds like you have been a good influence on many people, but you were a fatal influence on Ms. Gray and her soon-to-be born daughter. And that is a set of circumstances that carries with it some pretty grave consequences for you. Mr. Twitchell, I'm going to sentence you as follows in your case. As to count 1, I'm sentencing you to 15 years to serve 10 with a balance on probation. Count 2 is the same sentence. It'll run concurrently. Counts 3 and 4 merge into, I guess, count 1. They probably merge into count 2 as well. It doesn't matter. They merge. There's no sentence for counts 3 and 4. You'll get credit for the time you were in custody. I don't know how long that was. It wasn't too long, but you'll get credit for that. You are parole eligible. And we are talking about these numbers, which to you may seem large, but from the perspective of the major case prosecutor and a judge who typically sees intentional homicides, these are numbers that reflect the seriousness of the consequences of your decision, but an acknowledgement that you have more to give in this life. And you will have an opportunity to do that in a way that Ms. Gray can never again, and that her unborn daughter ever took that first breath. And we don't know what amazing things she may have done in this world. But you have a future. You will be out. And I appreciate Mr. App's observation that state prison isn't the right place for you. It's not the right place for most people who go there. But it is a destination for someone who ends up making the series of decisions that got you behind the wheel of the car that killed Ms. Gray and her unborn daughter. And for that, there are these very grave consequences. But again, you will continue to be able to call the people you care about. And at the end of the darker part of the upcoming years, you can resume whatever your passions are, be it culinary arts or forestry or whatever you choose to do. You will have the ability to make those choices. And what happened that night, based on the decisions you made, took from Ms. Gray the opportunity to make any more choices in her life, to hold her daughter, to share that birth with her other children and her mother and her grandmother and her uncle and others in her life. This doesn't bring her back, but it strikes what I think is the right balance given the gravity of the consequences of the decisions you made that day, juxtaposed with who you are, which is the transformer builder and friend of others, not an evil person, not a bad person, but someone who made some choices that were so bad that day that it took from our community, not one, but 2 people. That's the sentence. I am open, Mr. App, to having Mr. Twitchell report here because you don't report to jail, you report to court, to Deputy Gordon. I start a calendar on Monday, and I am open to having Mr. Twitchell report at 9 a.m. on Monday morning. He'd need to be here with nothing other than what he's wearing. Don't bring luggage, don't bring a belt, anything like that. But Monday at 9. You don't need to be here. You're welcome to be here. The person who has to be here is Mr. Twitchell. If he's not, then I impose the sentence that the state asked for.
I understand.
Okay?
We certainly would ask for that, Your Honor, so that he has some time to.
Well, it's difficult. It's what I struggle with. He has time to make a number of decisions that would be bad decisions for him, but he also has an opportunity to connect with family. But I take to heart Mr. Abadi's observation, one of his observations, that this case is 2 years old. And so Mr. Twitchell has known for a while that a plea could result in a custodial sentence. The state's recommendation wasn't a surprise. We've had final plea, et cetera. And so there ought to have been some preparation for a pronouncement from me that was different from what you advocated for. And I don't think your sentence was, I don't remember what adjectives you used, but it was a creative way to have a meaningful sentence. It's just not what I see as, in balancing things, a sentence that fully reflects the gravity of what happened as a result of Mr. Twitchell's decisions that night.
I understand.
So he has had time to prepare, and I'll give him a little more time. My concern is that not that he won't show up, because he adds 5 years to his sentence, and we'll find him. It's more so he does. I don't want him to make bad choices for his own well-being. That's what I really struggle with. He is surrounded with people who love him, and I trust they will keep him as up as he can be between now and Monday.
Yeah.
But I don't want it to go longer than that. I have had situations where someone doesn't report for the sentence because they've engaged in self-harm, and that's not what. I have no reason to say Mr. Twitchell would do that other than this is a difficult situation, and I want to be mindful of that.
The only other thing I would beg Your Honor to consider, I didn't hear the state oppose it, but certainly they might, and I had asked for previously, was to have Your Honor consider first offender treatment. He's eligible and he's going to serve a lengthy amount of time in prison, but as Your Honor heard, he's the totality of his life and who he is and what he's done with his life and what he wants to do with his life is going to be very different than the day this happened and the many years that he's going to serve in prison. And I am hopeful that Mr. Twitchell will do amazing things going forward after he gets out of prison. And I know that his family and friends want that to occur as well. So I would ask the court to please consider allowing him to plead guilty under the First Offender Act.
Mr. Abadi, you didn't address it because I don't think it came up in your presentation. It came up in Mr. App's. What's your view on first offender, given both the seriousness of the charges, but also Mr. Twitchell's, sounds like, complete lack of criminal history until this situation occurred?
So what I can say to the court is I spoke to the family about it, and they asked that I oppose it to the court, but I understand it's in the full discretion of Your Honor.
Okay. Mr. Twitchell, have you and Mr. App talked about how first offender works?
Yeah.
I'm going to talk to you about it a little bit more so you understand both the benefit and the risks. I don't know you very well. I've worked with you a little bit. I know you a little better now. But it was pretty clear to me from hearing from your family and your friends that what happened in February of 2024 wasn't a purposeful thing, that you are not, I can't say you're not dangerous because this is what happened. I mean, you make decisions that led to a death, but You were not on a trajectory of leading a life of crime, and I don't see you bending in that direction as a result of today. And first offender acknowledges that. And it means that if you successfully complete your sentence, to include the probationary period at the end, then you can try to rebuild without the burden of a felony conviction. It doesn't mean your sentence your sentence is no lighter. Your sentence will not be any shorter. That burden won't be lighter. But it does mean that you will reach a juncture where it will be easier to pivot from I'm defined by my inmate number and defined by probation. You'll carry the scars and the memories of what you did, but then you might be able to build something. And we lose a little less through this entire process. It doesn't bring Ms. Gray back or her daughter back, but instead of effectively labeling you in a certain way that would make it more difficult to give back to the community, you could move forward after you've paid your debt. There's a risk to it, though. The maximum sentence that I could impose in this case is 30 years, and I didn't. I understand that Ms. McGriff and her family were asking for more than what the state asked for, and I've shared why I think the sentence I imposed is the reasonable one. I don't need anyone to endorse it. It is what it is. But you need to understand that if during the time you are on parole, because you'll parole out at some point, and probation, we know there's at least 5 years of probation, if you were to get in trouble again, in particular, if it was anything related to you sped, you did something inappropriate with a car, anything reckless driving, et cetera, we'd be back together. And without a trial, because you've already pled guilty, the state would need to prove whatever this new situation is, pretty low burden of proof. We'd be talking about resentencing you. And if you, in fact, had deceived everyone into believing that the Mr. Twitchell of February 19th, 2024 was a horrific aberration. It's just not who you are. But in fact, you heard Ms. McGriff, she finds it hard to believe that you didn't typically drive in a reckless way. And I feel her when she says that. That's not what Mr. App presented, and I don't need to resolve that today. But you'd resolve it for us if 11 years from now, you T-bone a truck because you were driving too fast. That's the kind of thing that will get you resentenced, and we'd be talking about 25 years. And you get credit for the time you did, but you would just be recycling this process. And I share that with you not to threaten you in any way, because I doubt we would ever have that conversation. But you need to know what the risk of first offender is. It's if you don't think you could stay out of trouble and harm's way for the part of your sentence where you're not in custody. And frankly, in custody, I guess, I should tell you, if you stab someone in prison, that is a violation of your first offender status. I don't see that happening. But just know that if you commit a new crime during any point of this 15-year sentence, that's a reason to resentence you and talk about, boy, we misread this situation. Do you feel like you understand the benefit of first offender and the potential downside if things don't go the way you're hoping?
Yes, I do.
Do you want to be sentenced as a first offender?
Yes.
Okay. I am a big proponent of giving someone who faces a pretty meaningful custodial sentence with as much light at the end of that dark tunnel as possible. There are, I'm going to say 35. I didn't count the people here. There are 35 points of light right here that should help you get through that. But I'm happy to add one more, which is I'll sentence you as a first offender so that if you get through this sentence without too many bumps, then again, it doesn't mean you didn't do the things you pled to, but it means that you can close a chapter in a way that unfortunately Ms. McGriff's not able to do by having her daughter come back. And I know you won't forget about this, but at least you might be able to move forward in a way where you can re-engage with the community. Okay. Mr. App, anything else for Mr. Twitchell?
Nothing ever. He's to report to this courtroom at 9 a.m. on Monday.
9 a.m., courtroom 8D, Monday the 13th. If for some reason you're going to be late, let Mr. App know so he can call. If I hear from him, hey, he's on his way, all is well. But if it's 9:15, 9:30, I'm signing a sentence that's 15 years to serve, is what the state asked for. If you show up on time, it's exactly the sentence that I described that I find best fits the circumstances of this tragic situation. Okay? Early is great. Late needs to have Mr. App calling me saying, he's on 75. I'm on the phone with him. We'll handle it that way. Mr. Abadi, anything else on behalf of the state? Okay, I appreciate it. And I call you uncle because I don't know your last name, sir, but I appreciate you being here as well. And I wish your family the best that you can navigate from here. And thank you for being present in everyone's life.
Thank you. I'm Sterling Gray.
Okay, Mr. Gray, thank you for being here. And Mr. Gray, if you don't mind, if you would go with the victim advocate, I'm gonna have you guys go first before Mr. Twitchell's family and friends go, okay? Yes, sir. Ms. Nelson, are we using this same Zoom for the 3 o'clock?
Yes, we are, Judge.
Thank you.
Testing 1, 2, 3. Testing 1, 2, 3.
All right. Good afternoon, everyone. Before we get on the record, let's do a sound check. Mr. Fryer, can you hear me?
Yes, Your Honor.
All right. And Mr. Ingram, can you hear me?
Yes, sir.
Great. I know Mr. Armstrong can. I'm Judge McBurney. Mr. Ingram, you are of the three faces on the screen. Yours is the one that I haven't met before. And we are here to talk about a motion to withdraw a guilty plea from way back when. So let's get on the record. Ms. Rivers, you ready? This is 14 SC 128807. And before we get in any way substantive, I have two questions for defense counsel. One, are you feeling okay such that we should go forward right now?
Yes, Your Honor.
Great. Two, I noticed in the docket that there is a notice of appeal. Your amended motion that landed on people's desk only very recently says the Supreme Court has said, do your work, trial court. I don't see that in the docket. I just see the notice of appeal. I want to make sure that I'm not treading in spaces I'm not supposed to because I lack jurisdiction. And I don't know, Mr. Armstrong, if you've got a perspective on that. I don't know when Mr. Fryer came into the case.
So I can check if you give me a second to tell me the appellate court case number. I am aware of cases in the past year, especially where the remitter has not been e-filed, in the sense that there's some disconnect between the remitters that are getting back to us and the clerks actually getting notice of them.
Yes, or the clerk sends it dutifully to the trial judge who does nothing with it. And so
Cool.
Yeah, there's that issue too. So let's see.
I have the Supreme Court case number, if that's what you're looking for.
Is it a Supreme Court or Court of Appeals case, since there's no murder?
No, it was a habeas. So
I'll go to the other website. Just give me just one moment, please.
Yeah, Mr. Scarborough filed a notice of appeal in April of 24. So it ought to be resolved. It was 2 years ago, but
Habeas court initially granted an appeal. That's what that is. But the Supreme Court remanded it back to the trial court because they ruled that the original motion itself hadn't been ruled upon.
okay. Well, I don't have any of that, and I need to see some of it before I say I've got jurisdiction.
So now that they've said that, I think it might be in my email, but if Mr. Fryer would just tell me the case number, I'd be able to search for it.
S25A0172.
0S25A 0172. No, stop doing that. I don't want you to give me options that I'm not asking for. So it is reported, Your Honor,
Okay.
at 321.
Yep.
Georgia. $559.
I can forward a copy of the actual Supreme Court order. If
I'm good. Thank you. So what Justice Ellington said in this May 13th opinion is that this was to return to the habeas court. That's not me.
So the habeas court had decided it on its merits, and it was my understanding that the habeas court wasn't supposed to do that because it had not yet become ripe because the motion to withdraw was still pending. If I am wrong, you have my apologies, but that's what I thought was the outcome when I read this previously.
So I'm going to just read the last little bit. You're not wrong. I think there was something the habeas court still needed to do. We vacate the habeas court's judgment and remand, now this is my parenthetical, to the habeas court, not here, with direction that the habeas court give the parties an opportunity to supplement the record and to demonstrate whether Ingram's judgment of conviction is final for purposes of habeas review. If the habeas court determines that Ingram's motion to withdraw his guilty plea remains pending, this petition should be dismissed as premature. If the habeas court determines that Ingram's motion to withdraw his guilty plea is no longer pending, either way, that's a crossroads at the habeas court and not here. So if someone has something from the habeas court, then, and it says, we determine that the motion to withdraw the guilty plea remains pending, then we're in the right place. But I'm seeing for the first time the Supreme Court order, and I am not yet seeing anything from the habeas court.
So two things, and I'll look through my email to see if there is some issue on that somebody might have forwarded it to me at some point in time. But second, I wanted to mention that they did hold that the motion to withdraw was timely, and there's nothing in our record that indicates it was ever resolved.
Okay.
So it does still exist regardless of whether the habeas court has something going, I would suggest.
I don't disagree with you, but the Supreme Court said habeas court do something, and we're not in the habeas court here. What are your thoughts, Mr. Fryer?
I was concentrating on the sentence that says, if Ingram's motion remains pending, the trial court retains jurisdiction to alter or set aside Ingram's guilty plea and the resulting judgment of conviction. Like ADA Armstrong, I had not made the same link that Your Honor is making, but I do see what you're saying at this point.
Now, I appreciate it. I'm not making any link. It says, if the habeas court determines the motion to withdraw guilty plea remains pending, et cetera. So that's where the Supreme Court sent the case. They didn't send it here. That being said, we can go forward. I just don't know that Mr. Ingram has done what he was supposed to do to get here. I don't mean to make it sound, Mr. Ingram, like you've done something wrong. I don't know that it's even your burden, other than that, unless you've hired a lawyer, you manage your own habeas proceedings. And the Supreme Court didn't say trial court, it said habeas court. I appreciate that I'm being a little academic here because we have the prosecutor from the trial court saying the motion to withdraw the guilty plea remains pending. But the Supreme Court didn't say if Kevin Armstrong decides that it remains pending, or Mr. Fryer, or Mr. Ingram. It said if the habeas court determines it. And no one seems to be able to put their fingers on a ruling from the habeas court. They may take a different perspective. It may be incorrect if they say it's not pending, but that's the lane into which the Supreme Court slotted this case. Mr. Ingram, you need to wait and let your lawyer do the talking. If he wants to get some input from you, he'll say, client, what do you think? Mr. Fryer?
Actually, Your Honor, I got into this case. I was retained by the family of Mr. Ingram to deal with an issue in the Supreme Court, and I was blindsided by the remand, and I have not looked in that area. I haven't studied in that area. I guess I'm available to deal with it if it needs to be dealt with in that way, but I do not have the information to transmit to Your Honor with any definitive answers in that area. And it may very well be that Mr. Ingram, who has taken a great interest in his own case and is quite capable of understanding the issues, does have information that will be beneficial to the court.
And I would mention that he was the only defense person mentioned on the opinion.
Mr. Ingram was.
Correct.
Okay. Mr. Ingram, what do you know about, first, you are in Macon State Prison. Is that in Richmond County?
No, this is in Macon County.
Macon County.
Yes, sir.
Okay. What do you know about there being a finding from the habeas court about the pendency of your motion to withdraw your guilty plea?
I received an order in October from October of 2025 when the habeas court remanded it to Fulton County. And I believe my uncle, who is more technical, he said he saw it in Peach Court before they mailed it to me.
All right.
I don't have anything with the lower court's case number on it in my inbox since 2024 when they were appealing the habeas order.
So, Mr. Ingram, do you have that order with you now? I don't know if you've got like a stack of files with you or.
I do not have a stack of files with me. They don't let you travel with paper.
Okay. Well, we wouldn't want you to get a paper cut. So what you need to do, we're going to go forward today and at least start fleshing out why you should be able to withdraw or why you shouldn't. But you need to figure out a way to get a copy of that order to Mr. Fryer, and then he can make sure it gets into the docket here, just so we close that loop. It was closable based on everything I was hearing from your lawyer and from Mr. Armstrong. It just, at least in this docket, it hadn't been closed. So if you could see to getting that done, whether it's a attachment to an email or you get your uncle or someone to get it to Mr. Fryer, he will get it in the docket here. Okay?
Yes, sir. Your Honor.
All right. So getting substantive, as I understand it, you were twice indicted for the armed robbery to which you ultimately pled guilty. You had an attorney who passed away soon after an offer was made. And that offer, I don't know that it was ever presented to you, and that may be one of the things Mr. Fryer is going to develop today. You then had Mr. Harvey, lots of motions were filed, no motions were ever heard. The case bounced around from a few judges, and ultimately in 2016, you were in front of Judge Baxter, and you were then represented by, it sounds like both Ms. Kim and Mr. King, Kim and King, and you entered a plea of 20 to serve 15, balance suspended, after the state had offered, it was a blind plea, 30 to serve. And you went through with that, said, yep, all right, that's the plea. And then later you learned supposedly about, an offer that was supposedly made to Mr. Gort that wasn't communicated to you. You moved to withdraw your plea, and then not a whole lot has happened substantively with your case since then. Is that I know it's loose, but accurate enough rendition of the background, Mr. Fryer, or is there more you want me to understand about the process before we get into your grounds for authorizing the withdrawal?
Only that the offer on case 12 SC 110660 it was a written offer that's in the record in the clerk's office. It was filed on January 15th, 2013.
So it's in the docket of the 12 SC case.
Yes, Your Honor.
Got it. All right.
So there's no question but that the offer was made. The question and the issue that we are having and presenting to the court today is that Mr. Ingram didn't know about it, and because of the illness and death of his attorney, if it had been sent to his attorney, the attorney didn't get it either, and of course did not, was unable to and did not communicate with Mr. Ingram.
Okay. And then what's your understanding about, did it have an expiration date? Was it withdrawn? I mean, if it's something that was actually never communicated to either counsel or defendant, then it's not really something that could be, oh, Mr. King is on the call. Hold on a second. Mr. King, we're looking for an order from the habeas court from October of last year that pushed the case back here to Fulton County. And Mr. Ingram has it, he just doesn't have it in the room with him. So I may be getting ahead of us, and you're going to talk about how an offer that effectively was never conveyed is somehow a binding offer.
Not quite that specific, Your Honor. And there was a written line in the offer that said, this offer is good until February 3rd of
13?
Of 13, yes.
Okay, so we'll call it like a 2-week, is a little more than that, but it was a couple-week offer. And that was the offer, it was something to serve 10? Yes, 15 to serve 10. Okay. So ultimately, it was 5 years less than what Mr. Ingram got from Judge Baxter.
Correct.
Okay. Okay. Well, I don't want to ask you more questions because I think you're going to cover them, and some of those things you're going to have to prove up anyway. Is there anything else procedurally, Mr. Fryer, you want us to cover before we get into this?
Not at this time, Your Honor.
Mr. Armstrong, any other funky moving parts?
Not that I'm aware of, Your Honor.
Okay. All right, Mr. Fryer. The microphone is yours.
All right. Who is going to swear in Mr. Ingram?
We've got a Deputy Scott right here who can do that. He's going to come up to the podium so everyone can see him. I'll add that.
And Your Honor, I would ask that if there are witnesses that we can't see, that the rule of sequestration.
Sure. Well, you're going to be calling Mr. King? Mr. Fryer? Pardon?
I am not going to be calling Mr. King. I believe he was requested by the state.
Oh, I did suggest, because I assumed that this was going to be an ineffective assistance of counsel claim for counsel to make themselves available, because that's an ordinary thing that I do in cases like this. And so if Mr. King, if you weren't being requested by the defense, I don't need to call you. I was doing that so that there'd be no issue with having the attorneys present.
Got it. So, Mr. Fryer, you're all right if we release Attorney King?
Yes, Your Honor.
Thank you, Mr. King, for joining us. And I will release Officer Stallworth from pretrial because I don't think we're taking a plea today. So we're good with pretrial as well. Thank you both.
You're welcome.
I think I have an order. I just emailed you the wrong thing, but I think I just saw an order. It's Richmond County. And
Yes.
and I read the first portion of it, and it said that it needed to come down for, it needed to come back to Fulton for the motion to withdraw. So I'm about to send that to you guys.
Great. Thank
I'm
you.
just looking back for it through my email. I just found it, but I'm gonna send it to you guys. But I can be released?
Yes, especially if you send that email.
Thank you all.
All right. Bye-bye.
And please give it to Mr. Fryer because I couldn't find his email in my email.
Okay, I will. He used to use some ancient like dial-up email service, but maybe he still has that email address. We'll send it there. It was like before Mindspring, but we'll do that. All right, Deputy, if you could get in front of the camera there and swear in Mr. Ingram.
Raise your right hand for me. Do you swear affirm to the testimony, the matter of this case you shall give is the truth and nothing but the truth to help you? Speaking clearly, would you state and spell your name for the record?
Antonio Ingram, ANTONIO, Ingram, INGRAM.
When you're ready.
Thank you, Your Honor. Are you the Antonio Ingram who was indicted in case 12 SC 110660 in Fulton County in 2012?
Yes, sir.
At that time, what, if any, arrangements did you make to be represented in your defense?
My family helped me arrange for Mr. Gort, Cliff Lane Gort, to represent me in May of 2012.
At the time that Mr. Gort was retained, was there any issue as to his health that you were aware of?
No, sir.
Let's move ahead to January of 2013, specifically January 15th of 2013. Were you in court that day? Do you recall if you were in court that day?
No, sir.
Were you made aware of the fact that the state had made an offer in your case of 15 to serve 10 years on the armed robbery, 10 years concurrent on the aggravated battery, 10 years concurrent on the criminal damage to property, and 5 years, one to serve consecutive to the 1510?
No, sir. I was not aware.
Did you have any communication with Mr. Gort after January 15th, 2013 regarding that offer?
No, sir.
When did you become aware that Mr. Gort was very, very ill and that he subsequently died on January 23rd of 2013?
I believe the court clerk, not the court clerk, but Miss April in Judge Swall's courtroom made me aware that he had passed away, and I subsequently went to his funeral.
Say that very last part again, please.
After she made me aware, I went to his funeral, and I met his wife as well, Miss Sylvia Gordon.
When you were made aware in Judge Schwall's courtroom that Mr. Gort had
It
passed
was not,
away?
it was not in the courtroom. I didn't have a court date that day. I guess that's just the day they filed it.
Oh, all right. When you were made aware that Mr. Gort had passed away, what, if anything, was going on between you and the court in terms of your representation, since your attorney was no longer able to represent you?
The court didn't offer a public defender. I believe after that offer was made, my next court date was in February of 2013. And the court didn't offer a public defender. They just gave me more time to get an attorney.
And when was the next time after that that you had to be in court with representation?
The next scheduled court date was in April of 2013. I believe it was in April of 2013.
Were you able to obtain a new counsel to represent you at that point?
Miss Sylvia Gord, she helped me retain Bruce Harvey because she knew that her husband, I guess she knew that it was an issue, and she just helped me retain Bruce Harvey.
And what happened to your case while Bruce Harvey was representing you?
It was now crossed in August of 2014.
At any point after Mr. Gort passed away and the case was non-prossed, were you made aware of the fact that there had been an offer that was made back in January of 2013?
No, sir.
Let's move on to the indictment in case 14 SC 128807. Is that also a case that you were the defendant in?
Yes, sir.
And did that contain the same charges plus an aggravated assault as the previous indictment did?
Yes, sir.
Now, who was it that was your defense attorney under that indictment?
Kamani King and Judy Kim. Attorney Kamani King and Judy Kim.
Did either of them make you aware of the fact that there had been an offer made under the previous indictment?
Sir.
Let's move ahead to September 30th of 2016. That was the date of the guilty plea in case 14 SC 128807. Do you recall that date?
Yes, sir.
Do you recall what the state was recommending that you be given on a conviction?
I believe the state said maybe 30 years.
Were you in court on that day?
Yes, sir.
Were you planning to plead guilty on that day?
No, sir.
Do you recall who the judge was who was presiding that day?
Judge Baxter.
Had you had Judge Baxter involved in this case at any point before that?
No, sir. This Judge Glanville had recused himself because he knew the victim in August of 2016. And this was my first day in Judge Baxter's courtroom.
Do you recall?
So what was your plan, Mr. Ingram, if you said you were not planning on pleading to the case on September 30th? Were you definitively not pleading, as in, I'm going to trial no matter what? Or you were going into that day having discussed with your lawyers, maybe we'll work it out, maybe we won't work it out?
My plan was for the motion hearing to go through because I do, as I had discussed with my lawyer, I heard the police officer on the scene state that he stated that he didn't even match the description, but I had a gut instinct or a gut feeling. And that was my plan to go through with that. That was my plan.
So the 30th of September was a motions hearing date?
It was a motions hearing that led to that, but that particular ground was never ruled upon, and my attorneys didn't litigate it.
When you say that particular ground, this thing about the detective saying he doesn't even match the description.
Yes, he just had a good instinct. The motion to suppress illegal stop was not litigated upon nor ruled upon.
Okay.
Yes.
But that's what was supposed to happen on the 30th, was to finally have a hearing on the motion to suppress?
Yes, and we had a hearing. My attorney just didn't litigate those specific grounds. They litigated other things.
Okay.
For the court's edification, during the guilty plea hearing, or at least all that was recorded going up to the guilty plea hearing, Judge Baxter was saying that he had this case on the trial calendar for Monday. So it was going ahead to trial, at least according to the judge.
Is that a question, or you are sharing what was in the transcript?
Sharing, Your Honor.
Okay.
What, if anything, made you change your mind and enter the guilty plea on that date?
Shortly before I took the plea, Judge Baxter, he was like, this is going to be a train wreck. He was like, I suggest you guys come up with the best outcome that you can, because in his opinion, it's a foregone conclusion. And he said, this thing is going to get ugly. It's going to get real ugly. So I suggest you guys to find the best outcome that you can. And as the judge is telling me, in his mind, it's a foregone conclusion. I wouldn't take the judge's word lightly.
Do you recall Judge Baxter actually making a counter offer when the assistant DA said 30 years?
No, he didn't make a counter offer. Before the DA said 30 years, Judge Baxter, the DA said, I haven't offered anything below the mandatory minimum. and Judge Baxter said mandatory minimum. And the DA said, yes, I'm referencing the mandatory minimum armed robbery, which is 10 years. And Judge Baxter said, I don't think I'm going to be accepting that. I think I'll go 15 in this case. Judge Baxter was the first to offer a plea, and then he asked the DA what they were offering, which ended up being 30 years.
If Judge Baxter had not said the things that he said, and let me rephrase that. If he had not said the things that he said, would you have entered the guilty plea, or would you have wanted to go ahead even if it meant going to trial?
No, I would not have entered the guilty plea.
And why did you file or have an attorney file for you the motion to withdraw the guilty plea a couple of weeks after you entered the guilty plea?
Because I knew that motion hadn't been litigated properly. And I know what should have been the outcome of that said motion to suppress a legal stop of what I believe should have been the outcome.
I have no further questions at this time.
All right. Before Mr. Armstrong goes, I've got one, Mr. Ingram. In Mr. Fryer's amended motion that he filed, presumably after talking with you about the case, he says that had you, Mr. Ingram, known of the state's offer back in January of 2013, so this 15 to serve 10, so this is early in the case. Had you known of that and that 10 years was the lowest you could go for armed robbery, that's the mandatory minimum, you would have taken the plea offer. Is that a correct statement?
Yes, sir.
So you would have taken 10 years without litigating this police stop, but you're telling me that, boy, 15 years, no, I never would have taken that, but for the pressure from the judge, because I really wanted to litigate this bad police stop.
Yes, because I knew it could have got me a more favorable outcome because I was never offered the 10 years again. Thereafter, they kept offering, I guess because they felt their case got stronger, the pleas that they offered me were much higher.
Okay, well, and in the end, they recommended 30. So you're right, they tripled what they were recommending. But in February of or January of 2013, before any of these motions had been litigated, you were prepared to take 10.
Yes, sir.
Okay, thank you. Mr. Armstrong.
Yes. Mr. Ingram, I want to ask you about your memory of what the prosecutor was saying at the hearing. He indicated that
Which hearing?
I'm sorry, at your ultimate guilty plea hearing.
Yes, sir.
Thank you, Your Honor. He made a representation to the court that the defense had only been asking for a reduction to robbery in less than 10 years as a possible counteroffer to whatever the state was offering. Do you recall that?
I recall that in the transcript, yes.
And your attorney didn't contest that, didn't say that that was incorrect, correct?
Correct.
Now, tell me, what were your conversations with your attorney at that point in time about what you would be asking the state to entertain?
My conversation with my attorney, she just said that she was negotiating with the state. She never came back and told me any offer that the state had made.
So when you were talking in that conversation, what did you tell her you would accept?
I don't recall.
Okay.
So Ms. Kim had no knowledge of, hey, I'll take 5, I'll take 9, I'll take 11. She was just hoping that whatever she negotiated, you'd be okay with?
I guess, but she never communicated with me an offer that the state made.
But what Mr. Armstrong is getting at, and I'm following up on this, is what did you communicate to her? I hear you that she didn't come back and say the state said X or Y or Z, but if I'm your lawyer, I want to know, well, Mr. Ingram, what are you going to say? I don't want to waste your time and mine trying to squeeze a 10-year deal out of the state if you will only take 1 year. I'm not saying that was this situation, but what I'm trying to understand is what you told Mr. King or Ms. Kim or both of them, hey, if you can get me X, we can work this out.
Miss Kim, this was the first in court. This was the first time that I had heard that she had negotiated with them regarding the plea. I'd never heard this before.
Okay. And so it sounds like you had not ever had a conversation with either Ms. Kim or Mr. King about what would be an acceptable negotiated resolution.
Yes, I'd never had a conversation with Mr. King outside the courtroom. My first day meeting him, because somehow Miss Kim retained him. I really never had a conversation with him.
Okay. Your family hired Ms. Kim.
Miss Kim, yeah.
Got it. And she brought Mr. King in. So most of your interaction would have been with Ms. Kim.
Yes, sir.
Okay. And you never expressed to her what you thought would be a reasonable outcome in the case?
No. And I can explain to you the reason why, maybe.
Sure.
Because when the case was resolved in 2014, Bruce Harvey told me in the back, he was like, I asked him, well, what is a null pros? And he told me, as long as you don't get in trouble again, it shouldn't come up.
Whoops.
So you want me to go on or are you?
No, you can't. I mean, obviously that's not what happened.
Exactly.
Okay.
So that was the biggest thing that I was contesting. That was in August of 2014. I made a mistake and went to the courthouse when I was getting my license reinstated after I got out of Wright Street. And that's when I went to the Superior Courthouse instead of the, I believe the Magistrate Courthouse. And they told me, like, you have a pending warrant from Fulton County. So they apprised me of the situation. And when I went to Miss Kim, I was informing her that maybe they got the wrong person or something, because I am Antonio Ingram. I do see that there's another Antonio Ingram in the system, so maybe they got the wrong person. That was more so my contest with her, because the court even gave me documents with his case number on it, so it was kind of like a confusion period. And the court didn't appoint me an attorney then either, because they said I wasn't eligible for one. So it went on from all the way until 2016 when Miss Kim was retained without me having an attorney, which is almost a year.
Okay.
Mr. Ingram, you just said that when you were told that you had a warrant out for the new indictment, that you then went to Miss Kim and asked if they had the wrong person. Did I hear you correctly?
I was told that, and I went to court myself, and I asked the judge.
Well, I'm just asking very specifically what I just said. Is that correct or incorrect?
Can you repeat your question?
Yes. You said that when you found out that there was a new indictment against you and a warrant out, that you went to Miss Kim to ask her if they had the right person. Did I understand that?
Not in that order. Do you want me to give you a timeline?
Thank you. Well, first of all, you answered my question. Now explain.
Yes, sir. When I heard that, she gave me the next court date. I went so I wouldn't get arrested. And ultimately,
when you say that, what is that? When you heard that?
When I heard the fact that the court clerk told me that I had a possible pending bench warrant, and she gave me the next court date. So I went to the next court date, which was maybe a month later in February 2015. I went to that court date in Judge Glansville courtroom, and ultimately a bench warrant was not issued. And I was asking, I guess I shouldn't have been asking without an attorney, but I was asking, like, my lawyer told me that as long as I don't get in trouble, then the case shouldn't be reopened. And I was just sincerely asking, like, well, why is it reopened? And
Mr. Ingram, I think you've gone beyond the answer to the question.
Okay,
And
I'm sorry.
so I also would like to know, because I'm a little confused at the timeline. You indicated that there was this full year of litigation where you weren't having an attorney because you didn't qualify for one, and then your family hired Miss Kim. But you're also putting Miss Kim's involvement at the front end of the second indictment, where you went to her to ask if they had the right person.
No, this was when I did hire her. Those are the presumptions, I would say, that I hired her upon. That's the situation that I hired her upon. So that was the extent of me and Miss Kim's communication as to why is this open. That's why I'm mentioning that. That was the extent of our communication. Why is this open if my attorney told me that this case shouldn't be reopened? You see what I'm saying?
So you
As long as
knew
I
that
don't
you
get
had
involved.
the open indictment for a year before you talked to an attorney about whether it applied to you.
Yes.
Okay. Next, you indicated that you were upset that your attorneys did not litigate an issue with why there was two different descriptions provided for the suspect in the case. Did I hear you correctly?
Can you say that again?
What I understood your testimony on direct to be was that your main issue was with a motion about one description not matching you being given on the night of the armed robbery. Did I hear that correctly?
Yes.
Now, you were present for when Judge Baxter heard three separate motions on the day you pled guilty, correct?
For me, yes, sir.
Okay. And you remember the state talking about trying to get in an excited utterance from a person who had like stage 4 lung cancer.
Yes.
Okay. And you know that that was about explaining that the jacket of the person was no longer on him, and that's why that there was two descriptions on him.
Yes. Do you want an explanation or yes or no?
No, I'm asking if you were aware of that.
Yes, sir.
And you heard that your attorney opposed the court's request for that evidence to be admitted over hearsay and confrontation clause objections.
Yes, because the state had previously emailed that the victim, that witness didn't remember anything, and they wouldn't be entering anything from that. They wouldn't use that. He's a judge now, Scott McAfee. He emailed that to my attorney, and I did share copies of that email with prior attorneys.
Okay. So I just want to be very, very clear. What you testified on direct about being the motion that was not litigated, you now admit that that motion was in fact litigated before you took your guilty plea.
It was not litigated or ruled upon.
Well, what do you mean by litigated in your mind, Mr. Ingram? Because litigated to me means it was actually argued and witnesses came or lawyers argued. That's different from ruled upon, but it means that your lawyers were given an opportunity to say to the judge, you should do X because of Y. Did that not happen on that day?
When they were speaking about that was after everything, after the motions were litigated. They were speaking about coming to court for trial, them being ready for trial. They weren't speaking about for the motions hearing.
Well, but you just said after the motions were litigated. Tell me what else happened that day. I haven't read the transcript. Clearly, Mr. Armstrong has. I bet Mr. Fryer has. And you've referred to a transcript several times. Were motions argued in front of Judge Baxter on September 30th, 2016?
Yes, sir.
Okay, that's what I mean by litigated. If a lawyer has a chance to stand up, say, Judge, There's this situation, we think you should suppress it. Maybe there's a witness, maybe not, but at least there's a discussion with the judge about excluding something or suppressing something. That's litigating the motion. Did things like, go ahead.
I'm sorry for interrupting you, Your Honor.
Is that what happened in front of Judge Baxter that day before your plea?
Yes, I'm not speaking about, I'm saying that particular ground, that particular argument wasn't presented to the court. She did speak on other things, but she didn't litigate this particular ground. That's what I mean. I apologize if there's any confusion.
Okay, no, I'm understanding.
She didn't litigate the motion to suppress a legal stop.
Did the judge say she cannot do that, or she, Ms. Kim, in exercising her professional judgment, chose not to argue it?
She just didn't. And she didn't give me any reason as to why she did. Actually, Kamani King was the one who was litigating. I apologize. One who I never spoke with before, and he just didn't present the ground.
Okay, but it wasn't that Judge Baxter said, I don't want to hear it. Do not talk to me about the bad stop. It's that Mr. King and Ms. Kim decided what they were going to argue to Judge Baxter. And one of the things they decided not to argue is this concern that you have. Is that a fair statement?
I can't say they decided to or if they erroneously left it out, but I know that they didn't do it. I can't say what they.
Okay, well, I think we're saying the same thing. I'm not saying they made a good decision or a bad decision to leave it out, but it sounds like we're agreeing that no one prevented them from bringing it up had they wanted to bring it up.
Yes, sir. Exactly.
Okay,
Yes, sir.
got it.
Mr. Ingram, do you recall, let me orient you a bit. During your direct, you indicated that after you got out of the jail, you went to go change your license, and at that point, you learned of the second indictment. Did I hear that correctly?
Yes, sir.
When did you do that? When did you go try to get your license renewed following your release from jail?
That would have been in January of 2015.
Okay. Now, there are indications in the record, there are pretrial mini compliance reports, and I'm going to ask if this comports with what you remember. In January of 2013, a person with pretrial services indicated that you were not in compliance, that you had missed multiple meetings with them and had not directed to get a drug screen as required. Do you recall that?
Is that 2015?
2013.
The license was in 2015, so you.
Oh, I went back in time. I'm going back to January 2013 when the plea offer was put into the record.
Okay, go ahead.
Do you recall being cited by pretrial services for failing to report to numerous scheduled office visits and failing to report for drug test?
No, because I always went, and they came to see me multiple times a week.
Okay. Do you recall in April of that year them again saying that you had missed numerous meetings and that you had not reported since your new charges?
Excuse me, I'm going to object, Your Honor, on grounds of relevance. This is not responsive to anything in the motion to withdraw the guilty plea.
The motion to withdraw the guilty plea is based upon the idea that he has been deprived of his knowledge of information about his case during a period of time where it seems that he was not reporting to pretrial services, which indicates to me that he wasn't participating in the criminal justice system, which also negates the acclaim that it was his attorney's fault on his deathbed for not reporting this information to him.
So you intend to argue that Mr. Ingram had unplugged from the process as evidenced by the pretrial services reports.
And this also goes to the likelihood that he was willing to plead guilty to a case where his attorney ultimately got a dismissal of the indictment.
Okay, I'll let him continue to explore this.
Do you remember that from being in April 2013 about failing to report?
I do not recall ever missing a pretrial visit or appointment.
Were you aware of a bench warrant for you in April of 2013?
Also, I was a student at Morehouse at the time, so it would be impossible.
I'm asking if you're aware of one.
Go ahead.
Were you aware that there was a bench warrant in April 2013 for you?
No, sir.
Okay.
I believe I'm sorry. At an appointment is where they arrested me.
You indicated on direct that you had not had a conversation about acceptable outcomes with Miss Kim. Did I hear that correct?
I didn't have a conversation with her about any offers that were made by the state.
No, not offers, but what you would have accepted had the state made such an offer. Did y'all have any conversations about that?
No, sir. We had no discussions about an offer by the state.
Did you have any discussions with Bruce Harvey, your earlier attorney, about the type of sentences you would accept if offered?
No, only what the state was offering.
Okay. I believe you indicated earlier that the court said you were not eligible for the appointment of counsel. Did I hear that correctly?
The court didn't say it. The public defender, I believe it was Mr. Chow in Judge Glanville's courtroom. He said that, and Judge Glanville was urging him, and he was saying it's clear that he can't afford an attorney. So why don't you guys appoint him one? And Mr. Cho was saying that he doesn't fit the criteria. He's not eligible.
Okay. Your Honor, may I have a moment to go over my notes?
Yes.
I have no further questions, Your Honor.
Any redirect, Mr. Fryer?
No, Your Honor.
All right. Mr. Ingram, how long have you been in custody if you include time you were at the Fulton County Jail before you pled guilty?
I've been in custody 11 years. Next month, I would make 11 years total time served because I have a sentence computation sheet.
Okay. You were indicted in 2012, you pled in 2016. In that 4-year window, you also mentioned, I was a student at Morehouse. Were you mostly on bond during those 4 years, or were you mostly at Rice Street?
I was at Rice Street for, I believe, 17 months during that period.
When you pled, were you in custody?
No, sir.
Okay. Thank you. Mr. Fryer, anything else?
Only if Your Honor wants me to elaborate on the argument made in the written motion.
In your review of Judge the transcript of the hearing that ultimately resulted in the plea, but was a motions hearing at first, did Judge Baxter issue any rulings from the bench on the motions that were argued? Or it just kind of transitioned from arguing the motions to, this is going to be a train wreck, you need to work this case out?
No, the motions that they did argue, he did rule upon those, which was, and he denied those, the ones that they did argue.
Okay, so he did rule. It wasn't then Oh, I'm just looking at the grounds that Mr. Fryer has raised and sorting through whether I have any questions about them. I guess the one that I'm wrestling with the most is your first one, which is he had this offer, but it was never conveyed to him, and then it expired. You say it was withdrawn. It's sort of the same thing. And none of that seems to be Mr. Ingram's fault. That it's not that he ignored it, but his lawyer literally wasn't in a position to receive it and communicate it, and then he was deceased. So even more so. And that's a denial of counsel because he and his lawyer never talked about it. Just trying to think it like if we were in the olden days and the offer had been mailed, and the mailman put it in the wrong mailbox, and so the offer never got to Mr. Gort. Mr. Gort was perfectly healthy. He just never got the offer, and it expired. And then Mr. Gort rolls off the case. Mr. Ingram gets a different lawyer and doesn't even need to have as many twists and turns as this. It's just he has another lawyer, and then he ends up pleading to something that is more than the offer that never really made it. What's the legal argument that Mr. Ingram either should get that old offer or should be able to withdraw his plea to what was the new reality when he entered the plea?
Excuse me, the argument is that the overall concepts of justice and equity, due process of law, the ability to be represented by an attorney when making critical decisions at crucial points of the process in a criminal case, all say that the defendant has to have the opportunity to be counseled effectively and to make the decisions based on the best information and advice that the attorney can give. As I've said in the motion, none of this was in Mr. Ingram's control. It is, to my mind, monstrously unfair that he was not given the opportunity, because of the circumstances that he had no control over, to enter the plea as he has testified to today that he would have taken, knowing that it was the best he could get, and he could get a lot worse if he went to trial because of circumstances he had no possible control over. In a motion to withdraw a guilty plea, the key question is there manifest necessity to show that there was a manifest injustice that occurred? And I can't think of much that is either more of a manifest injustice than putting him in a circumstance where he had the opportunity to get a lesser sentence, but instead he winds up having to get a greater sentence because he wasn't given the opportunity to get the lesser sentence as a practical matter.
So let's go back to my example, because this seems akin to it. It doesn't seem like it was Mr. Gort didn't do what a lawyer should do in that situation, but I don't know physically that he could have. So I want to be very clear. I'm not faulting him. I'm certainly not faulting Mr. Ingram, although I'm going to hear from Mr. Armstrong a little bit about that. Well, but Mr. Ingram was sort of in the wind with pretrial at this point. If we go back to the mailbox scenario where it just gets put in the wrong mailbox. And so Mr. Gort he doesn't get the offer. More importantly, Mr. Ingram doesn't get the offer. And we learned this later because the prosecutor said, oh, well, back then, before we'd done all this other work and we learned more about the case, we'd offered you 10. What principles of contract would empower a defendant to say, you need to give me that offer again?
That is a separate question. Right now, we're only talking about withdrawing the plea, which is what Mr. Ingram wants to do.
But you're saying he should be able, I'm sorry to interrupt, but you're saying he should be able to withdraw because he never got this opportunity to do this plea that was lower. But he, in some respects, never had that opportunity because it wasn't communicated to him. But the failure to have it communicated was not ineffective assistance of counsel. It was serendipity suggests good outcomes, but it was serendipitous, just bad serendipity. It was unfortunate confluence of events that Mr. Ingram didn't learn about it in the window that offer existed, but it wasn't through deficient performance of anyone. And so why is that a basis to be able to withdraw a plea now? I appreciate it. It's not enforcing the old deal, but it's an unenforceable old deal, I think. And so why is that a basis to withdraw now? Or to have withdrawn at the time? I want to be clear. I'm not hung up on the fact that it's 2026. It was a timely motion to withdraw. I don't think anyone's fighting about that. So it was timely filed, but if what is being articulated now as the basis for that motion to withdraw is, hey, there was this better deal I never knew about, doesn't it need to be, and I didn't know about it because my lawyer was lazy, good for nothing, and ineffective, as opposed to the mail went to the wrong mailbox?
Ideally, that would be nice to have,
Yeah,
but I have to
would.
deal with what I have.
Okay.
And I fashioned the argument as an analogy to ineffective assistance of counsel who's sleeping through the proceedings and not providing good counsel. Most unfortunately for Mr. Gort, he couldn't. And the reason to do it is because Mr. Ingram is the one who's paying the price.
Right. And none of this is Mr. Ingram's fault, doing, responsibility. I follow that. Okay. I understand your point.
Ground number 3 follows closely on ground number 1.
When you say it follows closely, I mean, to me, it's pretty distinct. Did Judge Baxter, to me, it really doesn't matter about ground number 1. I think 3 stands all on itself. If Judge Baxter impermissibly coerced a plea, then this is withdrawable.
Yes, Your Honor. I didn't mean to imply that they were connected in terms of the legalities, but that 3 was in the importance of this particular motion close to 1.
Got it. Understood. It just happened to come last.
I did it chronologically.
Okay. Makes sense. Mr. Armstrong, your thoughts about the motion to withdraw?
Yes, I would begin with a point of clarification because there's an oddity in the record.
Just one.
There are 2 guilty plea transcripts, and I think I know why they exist that way. There's a 34-page guilty plea transcript that was filed in November of 2016 that actually includes exhibits that were admitted at the guilty plea hearing. However, somebody, it seems, requested the information from that whole day. And so in 2021, there is now an 86-page transcript, not with the exhibits, but just 86 pages, that includes those motions that were litigated that day and more fully fleshes out the information that was before Judge Baxter about the case.
Did you have both? I'm hopeful, Mr. Fry, you've got access to the whole docket, so you're aware of what Mr. Armstrong is saying.
I'm aware of what he's saying. I have the larger one. I don't have the smaller one.
The smaller one, it seems like it contains all the same information. It starts on a different part of the page where the guilty plea begins, but it has the exhibits that they talked about in the guilty plea hearing. And so there's visual images about the demonstrative, as well as the picture of Mr. Ingram smiling on the night of the robbery, the money that was involved, and certain other things.
We'll make sure you get that, Mr. Fryer, if you don't have it, although if you have it, it was in the docket.
Yes, but I can easily see how a human being, when they see guilty plea transcript, there's only one guilty plea that was entered. You're not going to go in
for a second.
And so I didn't see that one at first. I saw the 36-page one and thought it was pretty thin. And so I would point out.
Excuse me for interrupting. Let me say that all the cites to the transcript that are in the motion are from the longer one.
Okay.
Okay.
So right now the court has, to its benefit, only Mr. Ingram's testimony that he would absolutely have taken this guilty plea had he been made aware of it in 2013. And there's no circumstantial evidence whatsoever to corroborate that. In fact, there's evidence to the contrary, where you have, he basically said that he never talked to his attorneys about the type of resolutions that he would want from the case. Now, Your Honor is entirely correct that the cases that are cited are essentially ineffective assistance of counsel claims, and this isn't an ineffective assistance of counsel case. If there had been a case of ineffective assistance of counsel raised, what it would have looked like is Mr. Fryer having Bruce Harvey come in, or Mr. King come in, or Ms. Kim come in and testify about their decision, whether they saw that offer that was in the record, because they have discovery in the case. They got discovery somehow. I imagine it's because they looked at the record. You saw this offer was made. You know that the prior attorney died about that time. Why didn't you ask the state to simply make an exception and say, because of those circumstances, I'm extending the period of time for the plea? We don't have any of that before the court. And that's the more appropriate thing to happen when a defense attorney dies, essentially. I will admit that there are some strange decisions that have been made by prosecutors in this world, but that's one decision that I can't really foresee unless there's changed circumstances. And I imagine the changed circumstances as the case went on were the strength of the case. The hearings that took place before Judge Baxter addressed a reason for a Terry stop and a pat down of his pocket because as a side note, just to explain, when you go to places like Africa, which is what the victim was on his way to do, they don't mention this in the record, but I happen to know it, is that you get a better exchange rate if you have U.S. currency to hand over. And so he had $2,000 in U.S. currency that he'd gotten out of a bank, and it was stolen, and Mr. Ingram had a very large wad of cash that turns out to be about $2,000 in his pocket, and the officer who just knows that there's been a shooting is approaching this person who meets one of the descriptions and goes up to him, and he sees a bulge in his pants that he can't identify, and when he feels it, all he feels is a hard object because, as he said, the entire pocket was full. And so he reached in to determine whether it was a weapon. It wasn't, and he put it back in the defendant's pocket. And it was after more conversations with the defendant, him sweating, him having a little bit of blood on his shirt and other things, and more information from the people at the scene, that he decided to basically take him into custody and take him to the scene where there was a show up. And so the Terry stop and the show up were the main things that there were motions about that day.
Was the show up to the victim or to people who were with the victim?
It was a one-person show up, and it perfectly consisted with the Constitution, and Judge Baxter denied the motion against it. And I'll point something out.
But to whom was Mr. Ingram shown?
Oh, the victim who was
okay, that was my question.
I should mention this. The victim was just driving down a street at night, and somebody jumped out right in front of him. right before his car to get him to stop because he would have hit the person otherwise. And they start banging on the passenger side door, and he's just asking, like, what is going on? And then he starts getting shot. And he's shot in his right arm. He ducks. The car is riddled with bullets. His headrest has a bullet hole in it. So this was very close to being a murder. He says, give me that purse, which is this I think they described it as a purple bag that had the cash in it, pulls it, and then goes away. The victim goes into a parking lot and asks somebody for an ambulance, essentially. And he's waiting for the ambulance to get there because he's been shot, and he said he's bleeding profusely. He made a description to the police. And one of the things that I find particularly notable, because I'll get to this other part about it, about the excited utterance of another witness, is he provided one description to the police that involved a jacket. And with the show up, Mr. Ingram is provided to him in just a t-shirt with no jacket on. And he literally says, I thought it was strange because he wasn't wearing what I'd seen, but that is absolutely the person. And so like it solidified that, because the third motion, which the state indicated it had sent the email to Mr. Ingram's attorney, was that the state was seeking to have admitted as an excited utterance that was non-testimonial, somebody's excited utterance who was on scene, who told the officers that the man no longer had a jacket and had gone that way. And so there were two different descriptions. And so as Mr. Ingram said,
because there were two different appearances, jacket on, jacket up.
And that was addressed at the hearing. Now, he might have heard an officer say like something about two different descriptions, but that was part of the evidence. And so there's also one of the diagrams of where objects are left throughout the thing. The victim also said, like, I thought he was going towards this fence to climb over it. I didn't really see where he went after that. And so that's a description of the evidence generally that was dealt with on that day. In addition to that, this was going to be an overwhelming evidence case, because in addition to these things, which he was very nearby, he started sweating as though he was agitated and trying to breathe shallow, like he was trying not to raise alarms. Ultimately, it looks like the defendant had cut himself on a barbed wire going over the fence, and so he ditched the gun. The gun matched the shooting evidence, and the gun had his blood on it. The defendant's blood. And the judge was, I think, was a little confused, and there was an issue about that. That was just the thing that was holding.
I know what it was. I just try and figure out why it came off. We're good. We'll bill you.
And so I interpreted Judge Baxter not as trying to pressure the defendant into taking a plea, but the state into being more reasonable, because I think the state mentioned 30 years, and the judge is like, this is a lot. Like, what are we doing? And at that point, the state said, the defense has only talked to me about a deal where it's basically just like lowering it to a robbery and going below the 10 years, and absolutely not. You had a wildly sympathetic victim. And so I don't see this as Judge Baxter pressuring this defendant into doing it. I think it's him reasonably saying, like, I'm not going to do the mandatory minimum for this case because this was almost a murder. And so I don't see this as Judge Baxter leaning on this person. And I don't see any evidence that this is something that the defendant would have taken responsibility for and pled guilty for. And I did mention those circumstances throughout the record are pretrial services, compliance reports where they're saying that he's not reporting. He committed a new set of acts that March or April of 2013. Not armed robbery, but other things that got him arrested. And when it came down to the victim wasn't in pocket because he had a whole bunch of dealings in Africa. And so the state was asking, Your Honor, just so we can be sure that he is here before we swear in the jury, can we have a continuance until tomorrow? The defense did not ask like, hey, why don't we just have a low plea? They asked for a dismissal. They weren't looking for this man to have a conviction based on this. They were looking to have him go scot-free. So one thing that I found curious was the testimony that the case was resolved in 2014, and that meant that as long as he was fine, he was going off and dandy. I don't see Paul Harvey saying those things. He wasn't here to testify today, but on the record, you hear the judge repeat multiple times, this is not a dismissal, like I'm accepting this null process, but they can re-indict you. And so this is not something that would come in as a shock to the defendant. And I mention that mainly because if he had been seeking to accept responsibility and go with the mandatory minimum, that would be a chip to get it, because the state wasn't able to go forward definitively because they didn't have their main witness in pocket. And so the circumstantial evidence, I believe, is against the defendant's claim. All we have is the defendant's claim itself, and it is self-advantageous. And so I would
Sure, it's an offer that is less than the time he served, so it's an easy one to take now.
And so I would submit to the court that there is no manifest injustice in this case on either of the bases, no ineffective assistance of counsel and nothing of the other sort, and ask the court to deny the motion.
All right. Mr. Fryer, as the movant, I want to give you the last word. You've heard the state's case, and I am happy to hear.
Well, I think that the Assistant District Attorney has just made a beautiful case for why Mr. Ingram would have taken the first offer of 15 serve 10, because even though the motions to suppress had not been litigated, it was still an overwhelming amount of evidence against him. And the more evidence that there is, the more incentive there is to take the best plea available. And that was the best plea available. So in arguing against the motion to withdraw the plea, he's also making the case for the motion to withdraw the plea. And let me also emphasize the fact the motion to withdraw the plea was filed on October 27th, 2016. I didn't get into the case at all until it was up in the Supreme Court last year. So the fact that the motion to withdraw the guilty plea was filed then, I had no input whatsoever. I didn't even know Mr. Ingram at the time and had never represented him.
No, I understand that. And I also understand that the passage of time from then until now isn't reflective of anything other than this case bounced between too many judges, and there wasn't someone to take a hold of it back then and rule on it. Okay. Anything else, Mr. Fryer?
Just procedurally, if Your Honor gets the copy of the order from the habeas court, are you just going to go ahead and rule here, or how are you? What are your thoughts on how to proceed?
Yes, and you have it as well. Mr. King had it. He forwarded it to me and Mr. Armstrong, and Mr. Armstrong has since forwarded it to you. And it is exactly what Mr. Ingram said it was. The habeas court said, hey, the trial court never ruled on the motion to withdraw the plea. And so Judge Wright is sending it back to here, which means me, because Judge Baxter recused. So I think I'll get that put in the docket. But I think we are where you were hoping we were, that jurisdiction is back here.
Very good.
Okay. Mr. Ingram, do you have any questions about the things we talked about? Okay. Well, I will take this under advisement. I will enter an order. If I deny the motion to withdraw, that is still appealable. If I grant it, then do you have any other sentence you're under, or is this it? Okay, then you would come back here and be at Rice Street until we figure out what to do with your case.
Your Honor, before we conclude, I just wanted to add a point that I'd meant to mention earlier. You might see this when you're going over the case, and so I wanted to address it now. The motion to withdraw, as Mr. Fryer mentioned, was filed on October 27th, 2016. You might find that curious because the plea was, I believe, September 30th, 2016, which are different terms of court. However, the sentencing order was not filed until much later. For some reason, it was not filed till the following March.
Oh, right. I saw Judge Whitaker sign something. It was written by then ADA McAfee saying something about, hey, the sentence that was pronounced back then is in fact
Correct.
yeah.
And so I believe that the motion to withdraw became real at the moment the sentencing order went in. So it would have been the same term as the sentencing because it's the judgment of the court is the written order.
Right.
And so I just wanted to mention that in case that you had a question about that when looking over the record.
Great. No, I would have another funky wrinkle in this case. Okay. All right. Thank you, everyone, for your preparation. Thank you, Macon State Prison, for making Mr. Ingram available for us.
One other thing, can I get a breakout room with Mr. Ingram?
Sure. Macon State, can Mr. Ingram stay on for a couple more minutes?
I'll ask them.
You don't have to go anywhere. I mean, you can ask them. I'm just going to put the. Go ahead and ask. Okay, I'll create the breakout room.
Thank you, Your Honor.
Sure.
And when I'm done there, may I be excused?
Yes.
Thank you.
All right, so Mr. Ingram, I'm going to put you and Mr. Fryer into a breakout room. That's private. No one can hear you all, so you are able to speak free with him about what's going on, okay?
Yes, sir. Thank you, sir.
You bet. Let's see if we can make it work. There's one. And two. All right. Thanks, Mr. Armstrong.
Absolutely. I believe I'm the cause of this because when I was putting my plug in, I apparently pushed too hard and it came off. I thought I'd put it back. So I'm probably at fault.
If you'll re-anchor it, there are popular additions in these courtrooms because otherwise you have to get down on all fours to plug things in.
This was my first encounter with one, so I will hold it on this side the next time.
Okay. Huh, you broke it on your first encounter.
I don't think that I pushed it that hard. That last name is not real. Is there anything that you need from an ADA that I can bully them into giving?
No, I need to finish the ponder order. I started it, but I'm having trouble reconstructing what his lawyer was saying had changed over time, why the speedy appeal claim is valid, is what's the prejudice. And it had to do with reviewing what the jury charge was or wasn't. But I feel like the jury charge was given. They were able to argue voluntary.
So I think I know what it is, and this is going to be kind of in their favor. So I'm okay with that.
Okay.
Before 2007 in Georgia, defense attorneys could reserve. And that in that situation, they could